8:30 a.m. on June 18th, 2026, and I am calling the meeting back to order. Could we please have a member of staff conduct roll call, please?
Thank you, Mr. Chair. Mr. Thorwald,
Present, no conflict.
Ms. Browning,
Present.
Ms. Davis,
Present. My conflicts have been submitted in writing.
Ms. Walmsley,
Present, mine have been submitted.
Ms. Park,
Present, mine have been submitted.
Mr. Hogan,
Present, no conflicts.
Mr. Al-Nassif,
Here, no conflict for today.
Mr. Anderson.
Present, no conflicts today.
All accounted for, Mr. Chair.
Thank you, Dr. Gandhi. For those not in attendance yesterday, we do offer continuing education for attendees. For the morning session, you do need to sign in on the back table. So if you are interested, please do so this morning. If we move into an afternoon session after lunch, you also need to sign up on the sign-up sheet in the back for CE for the afternoon session. Moving right into the agenda, we are on tab 24, which is 24A, which is our administrative hearings. And this is for Mr. Eric Greg Embris. If Mr. Embris could come forward, please. And Mr. Embris, could you please introduce yourself for the record?
My name's Eric Greg Embris.
Thank you. And your witness?
My name is Steve Brees.
All right, thank you. This is the date, time, and place where the matter dealing with Eric Embris is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine whether to grant or deny Eric Embris's application for the renewal of his pharmacy technician license. The board is committed to ensuring that its business is conducted in a respectful manner. When conducting formal administrative hearings, the parties are expected to treat the board, witnesses, and each other with respect and in a civil and courteous manner. The parties shall not engage in any conduct that brings disorder or disruption to the proceedings. Neither party will be allowed to interrupt the board or the opposing party except where necessary to make an effective objection. If a party does not adhere to these basic civilities, the board will ask the party to modify their behavior. If the party continues to exhibit disruptive behavior, the party's microphone will be muted until their turn to speak. Board members present today include Jeffrey Anderson, Stephanie Spark, Lori Walmsley, Tennille Davis, Frank Thorwald, Tarek Al-Nassif, Chris Hogan, and Melinda Browning. Let the record reflect that the board members have been furnished copies of the complaint, notice of hearing, and all pleadings of record. If the respondent, Mr. Embris, do you have an attorney?
No.
Okay. You have the right to be represented by an attorney, but the law does not provide for an appointment of counsel on your behalf. If you want an attorney, it is your responsibility to secure and pay for one. By proceeding without representation of legal counsel, you're waiving your rights. This hearing is your opportunity to present testimony and evidence on your behalf, and if you appeal the board's decision, the record you make at this hearing today will be the evidence considered by a court in determining whether the board's decision was proper. Do you understand what I've told you, and do you wish to proceed without counsel today?
Yes.
A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. If in a license renewal denial proceeding, the applicant bears the burden of proof and shall present the case first unless the applicant defers to the state. Each party may make an opening statement. This is a brief summary of the case you intend to present today. Does the respondent wish to make an opening statement?
Yes.
All right.
Jean Galvin, Assistant Attorney General on behalf of the state.
Thank you, Ms. Ray. Thank you, Ms. Galvin.
Mr. Chair, just a friendly reminder to board members and the speakers out here is speak close to the mic so that the audience can hear you guys.
Thank you. Mr. Embers, could you please proceed with your opening statement?
First, I want to say thank you for allowing me to be here again. I know this is my second time. Also, I wanted to say thank you for the extensions that I've been receiving to continue working at the pharmacy that I've been working at. And in that time, I've been able to build back that trust that I did possibly lose. I did end up getting letters from technicians, the owner, and also the first pharmacist in charge of knowing pretty much what I did. And I am deeply sorry of what I did. I do really regret it.
Thank you, Mr. Embers. Does the state wish to make an opening statement?
Jean Galvin again on behalf of the state. The mission of the Board of Pharmacy is to protect the health, safety, and welfare of the citizens of Arizona by regulating the practice of pharmacy. The board accomplishes its mission in part by disciplining applicants for renewal who have committed unprofessional conduct. The case before you today involves Mr. Eric Ambrose. He is an applicant for renewal of his pharmacy technician license. He has been a licensed technician in Arizona since September of 2023. In October of 2024, Mr. Ambrose filed his application for renewal. And on that application, he disclosed that in April of 2024, he was arrested for theft in the third degree. The theft stemmed from his employment at Sam's Club, where he worked as a specialist. According to him, a specialist was someone who checked receipts as shoppers left the warehouse or who worked in customer service, the membership area. At today's hearing, through documents in the board's possession and the applicant's own admissions, he developed this scam in which he would conduct refunds to his and his brother's Sam Club memberships card and then place those funds on gift cards for use by him and another family member. He told the police that he had been involved in this conduct for 1 to 2 years, and he estimated the amount that he stole from Sam's Club was approximately $15,000 to $20,000. You will hear today from Ms. Jennifer Mitchell, board staff. She will walk you through her investigation into these matters, her communications with the applicant, and her receipt of the investigative records. At the conclusion of the hearing, the state asks that you find violations of ARS 32-1901.01C6, which is in part committing a felony or any crime involving moral turpitude. While no charges were filed against Mr. Ambrose, he has admitted to converting somewhere between $15,000 and $20,000 from Sam's Club for his own personal use. This is criminal conduct. Upon the presentation of the state's case, we respectfully ask that you uphold the board's denial of his application for renewal.
Thank you, Ms. Galvin. Does the applicant wish to testify or call any witnesses?
Regarding the 15 to 20K, that I don't believe.
Mr. Embers, I do have to swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Please proceed.
Regarding the 15 and 20K, that I know I did not take that much. Last time I was here, I did tell you guys that the amount that I believe that I did took, not monthly, but here and out, was 100 to 200. So if you do add up that with the, let's say the 2 years, it doesn't add up to the 10 to 20K that is being stated. I know I did do wrong, and I accept it, but I don't agree with that amount that they have accused me of.
State, do you wish to cross-examine the witness on his testimony?
Yes, I do. If he has concluded his,
Have you concluded your testimony?
Yes.
perhaps does he have any other witnesses?
Would you like to?
I'd like to speak, for Eric. My name's Steve Brees. I'm the pharmacist in charge at Safety Drugs, where Eric currently works. I was aware of the situation, since he's,
Mr. President, I apologize. A point of order. Mr. Reese is not allowed to just freely tell his side of the story, but he would have to be asked questions by Mr. Ambrose.
So, Mr. Ambrose, you have to ask your witness questions. This is a formal administrative hearing.
Did you know the did I tell you the theft that I committed?
yes,
How long have I been at Safety Drugs for?
almost 3 years.
Have you guys ever thought that I have done anything wrong or ever stolen anything at Safety?
No, you've been a great employee, honest, caring, one of the best employees that we have.
I don't have any further questions.
All right, thank you.
I do have a couple of questions for you, Mr. Ambrose.
Yes.
My name is Jean Galvin. I'm an Assistant Attorney General and I represent the state in this matter. The board is being provided independent legal advice from Deanie Ray, should they need it. But I am responsible for walking this case through this step of the procedure. You have stated your full name for the record.
Yes.
You were first licensed by the board in 2023, is that correct?
Yes.
Okay. We emailed you and mailed you exhibits that the state was going to offer on June 8th, 2026. Do you have them with you today?
The what again?
The exhibits were mailed to you and emailed to you on June 8th. Do you have them with you today?
No, I don't.
If I copy. If you would refer to what has been marked for identification as State's Exhibit number 2, the exhibits are tabbed for you.
Okay.
Does this exhibit, are those, is that at least first few pages of your application for renewal?
Yes.
And I apologize, members of the board, these were not date stamped, the exhibits, so I apologize that they don't have page numbers. A few pages in, we see that you had your electronic signature applied and your date of filing this exhibit was 10/6, is that correct? 10/6 of 2024.
Yes.
And the page prior to that, we have the regulatory question. And the regulatory question number 2, do you see that?
Yes.
And that question asks, since your last license renewal, have you been arrested, charged with, pled guilty to, or no contest to any felony or misdemeanor offense? And you responded yes to that question. Is that right?
Correct.
Okay. Did you submit a written response to the board explaining this arrest?
Yes, I did.
Okay. And if we turn a couple more pages after the application, we see a typed statement. And is that the statement that you wrote?
Yes.
And in keep referring to this exhibit, you were arrested for theft in the 3rd degree. Is that correct?
Correct.
And you state that you worked for Sam's Club in the capacity of a specialist. Is that right?
Yes.
What is the responsibilities? What are the responsibilities of a specialist?
So pretty much the specialist is they're pretty much jumping around. They're in the self-checkout, pretty much taking care of the members if they have any questions, helping them out, or they're at the door checking the receipts. And sometimes I'd be put in membership, pretty much doing returns.
Membership, did you say?
Yes.
Okay, thank you. Also, as part of your submission of your renewal application, you sent in a copy of the police report. Is that correct?
Yes.
And you were questioned by the police when you were confronted by Sam's Club management. Is that correct?
Yes.
Okay. The last 2 pages of exhibit number 2 are is that police report. Do you see that?
Yes.
Okay. Um, in that report, you explained to the police how you orchestrated this theft, correct?
Yes.
Okay. And you, if I read the report correctly, you would create false returns, and then the refunds that were generated from those false returns or fake returns, you would apply to your or your brother's Sam's membership card. Is that correct?
Pretty much I would return the groceries that I originally bought and then use that gift card to rebuy it from my membership and my brother's. But he wasn't aware of all the stuff that I was doing.
So you would bring back groceries that you had previously purchased?
Well, at that time, our Sam's Club return policy for pretty much food items, you didn't have to bring back. So I did take advantage of that. I returned everything and then we would immediately just throw it away. But when other members would do it, they would pretty much tell us that they have to bring it in to just do the return.
So as everyone understands, you would initially purchase groceries from Sam's Club, correct?
Yes.
Lawfully, and you would pay for them.
Yes.
And then when you were coming up with this theft, you would go to your account essentially,
Yes.
and without returning the food, you would essentially apply credit as if those items were returned and refunded.
Yes.
And then that refund would go on your membership account and your brother's membership account. Is that right?
Not go towards the membership. It would be a gift card.
A gift card. Okay, thank you. And you used your membership card to do these returns, is that correct?
Yes.
And your brother's membership card, is that correct?
Yes.
And then you would have the gift cards. You would take possession of the gift cards.
Yes.
Yes, okay. And this happened in 2022, 2023, is that correct?
Correct.
Okay. You told the officers at that time, and if you see this, it's about the second to last full paragraph of the report.
Yes.
You stated that over the last 2 years, you acknowledge it had been going on for about 2 years, and you had stolen funds through these fake returns, and gift cards in total of $15,000 to $20,000, correct?
Yes. Because at
Okay. That's what you told the police that you had converted.
because at that time when I first was brought up to the room with the store manager, she pretty much made me estimate how much. She didn't tell me how much I actually did. So when she asked me that, I was just bumping up the number, and that's the number that I ended up telling the police because that's what she made me believe.
Are you saying that the manager gave you this $15,000 to $20,000 number, or you offered this $15,000 to $20,000 number?
She pretty much told me that that amount is the amount that I stole. So that's what I told the police at that time.
And was that based upon, if you know, based upon records that she was referring to or looking at?
I'm not really sure how they got that number.
Okay. But you acknowledged that there was a theft that you had engaged in from Sam's Club over a 2-year period, correct?
Yes.
If your written statement back to the board, if we can go back to Exhibit 2 and the typed statement, it's the second sentence reads, "The reason for my actions was because I felt hopeless and responsible for my family's suffering. My single parent mother would work 2 jobs to support my brother and I." And your brother that you are referring to is Angel, correct?
Yes.
And he also had his own membership card, is that correct?
Yes. Because
So how old were you when this was going on?
I was 24, I believe.
24. And how old was Angel?
Him, like 18.
18. So are when you talk about your family suffering and your single parent supporting your brother and I, it was just you and your brother. There weren't other infants or children at home. Is that correct?
No, just us two.
Okay. In your written statement, you acknowledge that you acknowledge and take full responsibility for the concerns outlined in the board's notice, specifically the incident referenced in my application. Did I read that correctly?
Yes.
And I'm sorry, board, this is his request for hearing. And that is at exhibit number 12. Is this, if you could refer to exhibit number 12, Mr. Ambrose, is this the written statement that you provided to the board requesting a hearing in this matter?
Yes.
And the second full paragraph starts out with the sentence, I acknowledge and take full responsibility for the concerns outlined in the board's notice. And the concern is the theft that you had orchestrated. Is that correct?
Yes.
And were you told the police that you diverted $15,000 to $20,000 from your employer? Is that correct?
Yes.
I'm sorry, yes?
Yes.
Okay. And then down another sentence or two, you characterize this conduct over a 2-year period of time that resulted in, $15,000 to $20,000 in your own words of a theft as a lapse in judgment. Is that correct?
Yes.
The next paragraph says, since that time, I have taken meaningful and consistent steps to demonstrate personal growth, accountability, and professional integrity. Did I read that correctly?
Yes.
Okay. And as an example of this personal growth and accountability, you state that you have remained active in the pharmacy profession. Is that right?
Correct.
Okay. And that you are gaining hands-on experience, correct?
Correct.
So in terms of personal growth and accountability, have you made restitution to Sam's Club for the thousands of dollars that you diverted from them?
I have not, because I haven't.
You have not?
No.
Okay. One last question. You testified when you worked at Sam's Club as a specialist, one of your duties was to be at the door checking shoppers' receipts as they left the warehouse with their merchandise. Is that correct?
Yes.
Why would Sam's Club want their employees to check receipts before shoppers left with merchandise?
Pretty much to see if any missing items would pop up on the device.
So to make sure they weren't stealing.
Correct.
I have nothing further.
Thank you, Ms. Galvin. Mr. Ambrose, did you have any questions for the state?
I do want to say that I was able to get that fingerprint clearance card from last time that I was asked if I had it.
Do you have any questions for Ms. Galvin regarding what she was just asking you?
No.
That actually wouldn't be appropriate. She's not testifying.
Okay.
This is not working. You might ask him if he has any testimony in rebuttal of the cross-examination.
Do you have any testimony in rebuttal of the cross-examination?
I mean, I did want to say that I was able to get my fingerprint clearance card again when that was taken away when I was arrested. And I did state that on the statement that I did send as well. So I wanted to clear that up as well.
Thank you, Mr. Ambrose. Ms. Galvin, would you like to cross-examine his witness?
I just have one follow-up question for Mr. Ambrose. You said that you have received a fingerprint clearance card. Did you receive a good cause exception?
Yes.
Do you have a copy of the valid fingerprint clearance card?
I have it right here.
But do you have copies for the board to review or for
No.
me to review?
No.
Okay. You said you had letters from your pharmacists and pick and technicians. Did you bring those with you?
Yes, I have them right here.
Okay. Do you have copies for the board members?
I only have one.
Okay. He has not offered that into evidence. I don't have any questions for Mr. Reese or Mr. Ambrose.
All right, board members, do you have any questions?
I'm sorry, can board members ask witnesses or
Sure.
we cannot? Yes, just a question to the witness here. So, I mean, Mr. Reese, right? That's your name?
For me?
Yeah.
Yeah.
Yeah. What's your name again?
Steve Brees.
Okay, Steve. Sorry for that. So, just briefly, just tell us, I mean, how long you've been working with them. And you already mentioned like he's a good employee and benefits, but there is any concern, like how many hours a week, something like around
Sure.
this.
Eric has been a full-time employee with Safety Drugs. I think August will be his third year. I became PIC about a little over a year ago, last May. So prior to that, I worked alongside Eric as a pharmacist. And he usually the same shift in the morning shift, and he works 40 hours a week, if not more. He always willing to pick up hours, anything else. If we need help, he's always willing to do that too. And just during the time, I've been working alongside him, and then also now as the pharmacist in charge over him, he's been completely clear with everything that's gone on. I am aware that he's never been charged with anything. Everything was dropped. And as far as work goes now, I mean, yeah, he's reliable. He's a full-time employee. He's a huge part of our pharmacy team.
How many staff do you have?
We have, I believe, 58 right now, technicians and pharmacists.
Okay.
And drivers and whatnot.
And what type of pharmacy is
It's
it?
a closed door pharmacy, long-term care. So we deliver to skilled nursing, assisted living, and hospice.
Does he handle any cash?
There's no cash. No, it's not open to anybody. No cash comes in whatsoever. Everything's done through a billing office. The homes pay us or the hospices pay us.
Okay. Thank you.
No cash.
Thank you.
Yep.
Any other questions, board members? Mr. Ambrose, do you wish to call any additional witnesses?
No.
Do you rest your case?
Yes.
All right, Ms. Galvin, would you please call your witness?
Yes, the state's witness would like to call Jennifer Mitchell.
Ms. Mitchell, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Mitchell, will you please state your name for the record and spell your last name and tell us who you work for?
I'm Jennifer Mitchell. That is Mitchell, and I work for the Arizona State Board of Pharmacy.
And in what position and how long have you had that position?
I'm the executive assistant to the executive director, and I've been an executive assistant for 8 years.
Okay, is that the full time that you've been with the board?
No, I've been with the board for 12 years.
Okay, and what did you do prior to the current position?
I was the licensing division manager.
Okay, are you familiar with the respondent in this case, Mr. Ambrose?
I am.
And how is that?
I processed his license renewal application.
Turning to exhibit number 1, what is that exhibit, please?
That is a copy of Mr. Ambrose's pharmacy technician license.
Okay, and he was first licensed in September of 2023, is that correct?
That's correct.
If you look at exhibit number 2, that's been marked for identification, what is this document?
That is a copy of Mr. Ambrose's 2024 license renewal application.
Okay, and with respect to the regulatory question number 2, does he respond yes to that question?
He did.
And what does that question generally ask?
If the licensee has been arrested for, charged with, or pled guilty or no contest to, or been convicted of a felony or misdemeanor offense.
Okay, and he provided a written statement explaining that conduct.
He did.
Do we see that couple of pages in that's addressed Dear State Board of Pharmacy?
Yes.
Does he state in here why it is that he engaged in this theft?
He stated that as previously mentioned, he was feeling hopeless and responsible for his family's suffering. His single mother was working 2 jobs to support him, and he was a full-time student and a part-time employee at Sam's, which led to him feeling like it was easier to steal, than to possibly changing to be a part-time student and a full-time employee.
And that's contained in his statement.
It is.
He also attached as part of this application the police report. Is that correct? And that's the last 2 pages of the document.
Correct.
Okay, and he admitted to the diversion of those funds from Sam's Club, correct?
He did.
You heard his explanation of what specifically he did in conducting this theft. Is that outlined generally in this report?
It is.
And you understand, do you, that he was arrested for this conduct, but charges were not filed? Is that right?
That's correct.
Going to exhibit number 3, can you tell us what that document is?
That is a printout of the fingerprint clearance card status request from the Arizona Department of Public Safety's website.
And what did it show at the time that this was provided? What was the status of his fingerprint clearance card?
Not valid.
You heard Mr. Ambritz testify today that he has now a valid fingerprint clearance card. Has that been provided to the board?
No, it has not.
Okay, thank you. If we could go to exhibit 4, 5, and 6, members of the board. Ms. Mitchell, generally, are these email communications between you and Mr. Ambris regarding the status of his application?
Yes, they are.
So kind of procedural matters, is that correct?
That's correct.
Okay. Exhibit number 7. Can you identify this record for us?
That is the staff's memo to the board regarding Mr. Ambers' renewal application and his disclosure on that application.
Okay. Does this investigative report, it was authored by you, is that correct?
That's correct.
Would you say the information that is contained in this investigative report generally contains the information that we've heard at some point during this hearing?
Yes, it does.
Exhibit number 8, is that just a or a notice that to Mr. Ambris that his application will be considered at the board's February 2025 meeting?
It is.
Okay. And exhibit number 10 and 11, is number 10 an email showing the transmittal of the notice of denial to Mr. Ambris?
It is.
And at exhibit number 11, is that the notice of the denial that was sent to Mr. Ambris?
Yes, it is.
And this is the subject of today's hearing?
It is.
What is the factual basis for the denial as set forth in this notice?
Mr. Ambers' license was denied due to his admission to theft, which is an act of unprofessional conduct in the Arizona Revised Statutes.
And at exhibit number 12, is this his written request for a hearing in this matter?
It is.
Members of the board and chairman, I would like to move exhibits 1 through 14, with the exception of number 9, into evidence, asking you to take notice that exhibit 14 is the notice of hearing in this matter.
Thank you, Ms. Galvin. Mr. Ambrose, those documents, any objection to those accepting or being submitted to the board as evidence?
They're all correct. I just do have one question. Where does it show the email that I sent Ms. Mitchell that I did acquire my fingerprint clearance card?
Mr. Chairman, members of the board, I believe it was Ms. Mitchell's testimony that the board did not receive notice that he has a valid fingerprint clearance card.
Thank you. Do you, so do you accept the evidence that's been submitted here?
Y- Partially, because I did email her the when I end up getting that new fingerprint clearance card, and I was wondering where here it shows where I sent Miss Mitchell that information.
So apparently we don't have it. She testified she does not have that information that you submitted the fingerprint clearance card. So we don't have that in the evidence today. So any objections to what we have presented?
Yeah, I object that evidence.
So Ms. Ray, do you have some guidance for us?
I mean, he's not objecting to the evidence that's been presented. He's objecting to the fact that there's evidence missing, which I think he probably has the obligation to provide. So I guess you have to decide whether you have to decide whether or not you're accepting his objection or overruling it.
If I may, the state would stipulate that in preparation of this hearing, yesterday or the day before, Ms. Mitchell reviewed the DPS website and confirmed that he does have a fingerprint clearance card. Evidence of that fingerprint clearance card was never submitted to the board. Regardless of whether he says that he sent it and there should be an email, in the state's opinion, does not go to whether these exhibits should be admitted.
Based on this information, I think we should accept the documents into evidence.
Mr. Anderson, I'd like to make a motion to accept the exhibits as proposed by the state into evidence.
Second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Board, do you have any questions?
I do have a couple of questions of Ms. Mitchell. Ms. Mitchell, at the end of this hearing, what is it that the state is seeking in terms of resolution?
Upholding the denial of Mr. Embers's license renewal application.
And why is that?
Based on the extent of the crime and the number of years involved and the amount of money that was taken, the state would like to see that the renewal denial be upheld.
Thank you. I have nothing further and the state would rest.
Thank you, Ms. Galvin. Thank you, Ms. Mitchell. Mr. Embers, do you have any additional questions?
No.
Do you rest your case?
Yes.
All right. So this concludes the evidentiary portion of the hearing. The board will now hear any closing comments. The state may make a closing comment or an argument. The applicant may make a closing argument, and that's the process. Does the state have any closing argument?
I would be happy to go first, or because Mr. Ambers carries the burden, he could go first as well.
Mr. Ambers, would you like to go first?
Well, again, I just wanted to say thank you for having me here again. And I know what I did was extremely wrong, and I do regret it. And pretty much all that was said is true, other than obviously the amount, but I can't pretty much prove that. Whether or not you guys do decide to give me the license or let me keep it or not, I fully understand your guys' decision. And yeah, thank you.
Thank you, Mr. Ambers. Ms. Galvin, would the state like to make a closing Argument?
Briefly, members of the board, the evidence presented today by the state at today's hearing is uncontroverted. The documentary evidence against Mr. Ambrose, as well as his admission to thousands of dollars in theft from his employer over a period of 1 to 2 years, clearly prove the allegations leveled against him. This is not an instance, board members, of an employee taking a sandwich from the front end of the store or taking some wings and a soda from the deli without paying for them. This is theft and dishonesty on a grand scale. Let's say that the applicant operated this scheme for 18 months and the total amount he enriched himself by was $18,000. That's $1,000 a month for 18 months on average. He would process these returns and place the refunded amount on gift cards under his name for his benefit, using information on his membership card and his brother's membership card. His explanation for these events is that he submitted to the board states that the reason for my actions was because I felt hopeless and responsible for my family's suffering. My single parent mother would work 2 jobs to support my brother and I. He said he stole groceries for his family so they could eat. Recall that based upon his testimony, when these thefts were occurring, applicant was in his early to mid 20s and his brother was 18, old enough to have his own membership card, and he was enriched by applicant's criminal activity. This is not a case of a little old lady living in a shoe with a number of children who she had to feed and who were hungry. These kids who were allegedly did not have enough to eat at the time were in their early to mid 20s and 18. He has presented no evidence that the $15,000 to $20,000 he converted for his own use was used to buy groceries for his family. Applicant characterizes his actions as a lapse in judgment. A lapse of judgment suggests a temporary failure in decision-making, like making a bad joke at an inappropriate time. Here we have a systemic scheme created and implemented by applicant over and over for months and months for his own benefit. He estimated stealing between $15,000 and $20,000. That is what he reported to the police. This is not a lapse in judgment. 2 of the core foundational expectations of those working as a healthcare professional is trustworthiness and the exercise of sound judgment. Applicant has demonstrated neither. As an employee of Sam's Club, he was entrusted with access to their computerized membership data and merchandise system. Instead of accessing that information to carry out his work responsibilities, he used it nefariously to benefit himself. He didn't do it just once or twice, but over a very long period of time, demonstrating a lack of trustworthiness and a lack of sound judgment. One thing is very clear at the end of this hearing, he has failed to demonstrate to this board by a preponderance of the evidence that he is deserving of a license as a pharmacy technician. He has not carried his burden. Conversely, the state has demonstrated, in part through applicant's own admissions, that he is engaged in conduct that renders him undeserving of a state-sanctioned license. The only reasonable and justifiable action that the board must take today is to adhere to its mission to protect the public by upholding your denial of his application for renewal, and by finding that the evidence, uncontroverted, offered today by the state proves the violations of statute as set forth in the notice of denial. Thank you.
Thank you, Ms. Galvin. The board can now begin with general discussion to determine if the applicant demonstrated that they meet the qualifications for licensure set in board statutes. So the floor is open for discussion.
I have a procedural question. Is our only option today to approve or deny his request? Sorry. Or do we have an option to come up with some other sort of remedy, like a consent agreement that we offer?
I think in this case, you've got the question of whether or not to uphold the denial. but you do have the power to make an alternative decision.
The gentleman appears to be successfully practicing in this pharmacy that is a closed door pharmacy without any access to funds. And I wonder if we would be able to allow him to continue to practice under some sort of consent agreement with a practice restriction.
I've been thinking the same thing, to give him another opportunity, but where he doesn't have access to funds, the only thing that concerns me is the ability to potentially take drugs and sell those, and that's my concern, and I haven't been able to decide what's best in my mind yet.
I largely agree. I think the extent of this theft proves how while he's been practicing as a technician, I think it shows really bad judgment. And I think that, you know, as a technician, having access to controlled substances, it is certainly concerning. I don't know how I feel about it.
Mr. Brees, in your pharmacy, is there any workflows where technicians are not involved with controlled substances?
Yes, there is. But also in regards to how we monitor a controlled substance is lot caged. I mean, since we do service long-term care and hospice, there is controlled substances, obviously. But how we monitor it, 6 cameras inside a cage where they're all located, access key in and out. You know, pharmacists are the only ones that can bring anything in and out of that cage. How we keep up with our inventory, the counts, everything else is, we would notice if something was going on right away, and there hasn't been. I just think our security system is, especially for controls, is pretty flawless.
The problem I have is if we approve a license, there's nothing to say that he can't leave and go work at another pharmacy tomorrow where he would have access to drugs or money.
And just a counterpoint, if we granted the license and put him on probation, the probation could say he has to be at this employer. If he changes employers, he has to come back in front of us.
If it was something like that, I would be for it, or that he can only work in this type of a facility where that kind of restriction applies.
I like where you were going, Mr. Anderson. I agree that this shows a severe lack of judgment. He just has been successful in this current environment, and I guess I would like to see him continue to have an opportunity to make amends.
So Ms. Galvin asked you about restitution to Sam's Club. What's going on with that?
I pretty much wasn't able to go back at all and to Sam's Club because they didn't allow me to go back there. Since I didn't have court at all, I don't know anything. The only thing I know that it wasn't filed, so I wasn't able to pretty much do anything regarding that.
Thank you.
Remind me, the charges were dropped, correct?
Yeah, they
Which
were.
is why there was no restitution required, because the
Correct.
charges were dropped.
Correct.
To be clear, no charges were ever filed.
Oh.
So there was no court-ordered restitution, but obviously that would not prohibit him from voluntarily accepting accountability and repaying Sam's Club.
Did you sign any sort of commitment for restitution with your previous employer?
I did write a statement when I was about to get arrested with them that I would, if given the chance, that I would pay them back. I just don't know the process of doing that, so that's why I haven't done it.
Could we include something like that within our,
Don't decrease, Ms. Day, Ms. Ray, excuse me, don't decrease a censure, or is there some mechanism to require restitution to?
The question is whether or not you have the power and authority to order him to make restitution outside of, regulating. I'm sorry. Okay, I'm sorry. The question is whether or not you have the power and authority to ask him or order him to pay restitution in some, criminal matter. And I'm not really sure of that answer. Maybe Ms. Galvin has a position on that. But I mean, you can do a lot of things through a consent agreement. So it's worth, discussing.
It would be, Mr. Chairman, members of the board, the state's position that you could not order restitution be made by Mr. Ambritz to Sam's Club in a matter that is criminal in nature. But again, he could have done it voluntarily. He stated he signed a statement that said he would make that restitution. He just testified here apparently that he didn't know how to start that process. The state would be curious if he ever inquired of Sam's Club how to start that process.
Mr. Ambrose, can you answer her question, please?
Well, since I wasn't able to go personally there, that's why I've been avoiding Sam's Club. I'm not, and I don't have any of the manager's numbers to ask them like how I could pay them back or anything. So that's why I'm not sure.
So, Mr. Ambrose, so what I read, so you got arrested, but there's no one filed charge against you, right?
Yeah, no one filed charges now.
Is that in return to pay them back? That's why they didn't file charge against you?
That
There's any verbal discussion between you and people was in charge of Sam's Club?
Since that day that I got arrested, I haven't been in touch with any of them. I don't. That's why.
So, if you're willing to pay them back, and you don't know what the process, have you reached out to them by email? I'm sure you have emails or phone number or something to arrange those payments. And the reason I'm asking you, I mean, I'm not gonna force you. I cannot force you to pay them back. But to me, that reflects character. You know what I mean? Like if you accept this misconduct behavior, and then you should have do something.
Yes.
Right? That's how you show good character, right?
Yes.
If you claim this is lack of judgment, otherwise it's not lack of judgment. That's to me. All right, but that's my opinion.
Very good discussion, board members. Are we at a point where somebody's willing to make a motion?
Am I able to say something on that?
I mean,
One last comment.
What he said is true. I do agree with that. But since I was banned from being there, that's why I haven't done it. And the police and the lawyer at the time that I did have advised me not to go over there. But if I do have to find an email or call them, I would. I really would. And I would, the amount that they would want me to pay, I really would pay it back.
That's what Mr. Nassif was saying, is that there should have been some sort of good faith effort to do that prior to where we are today. And it sounds like there's never been that sort of good faith effort to make them whole for what you've stolen from Sam's Club.
Yes.
Just because you were trespassed or whatever reason you can't be back on the property is your reason why it sounds like you haven't attempted to make that restitution to them.
And absolutely, I don't want to go there and trespass there. Definitely not. You cannot do that. But it just, like you need to, you should have done something else, right? Like hire a lawyer or something or consultant to reach out to them on your behalf and arrange this. However, this is a different discussion. And I can see that you really progress and you're doing well at this time. So I appreciate that. To
Board members, motion?
I'm not sure how to formulate the motion. I would like to see us give him another chance as long as he's in an environment with those kinds of restrictions. I'm not sure how to formulate that motion. Does council have any advice on how to do that?
Are you thinking about making this into a consent agreement where, okay, so I think perhaps it might be useful to ask Mr. Embrus if he would be willing to consider that if you were to offer a consent agreement in which you allowed him to continue to work with certain restrictions. And then if that's the case, also ask Ms. Galvin what her position is regarding that. And then you may have some idea of how to go forward.
Would you be willing to accept a consent agreement?
Yes.
I have a question, Ms. Ray. So since we're at a stage of an administrative hearing, can't we just order probation if that's what
You
we wanted
could-
to do?
Yes, you could.
And it wouldn't have to be packaged in a consent agreement?
That's correct. The reason I suggest a consent agreement is that drafting an order like that takes a considerable amount of, it's very detail oriented. It might be helpful if you had those sections and requirements in front of you and drafted, because it's going to be difficult for you to come up with all the requirements that you need to have for that kind of order. So you could ask the parties to come up with an agreed order for the board so that you don't have to try and devise all of the different requirements that you need to make it work. Normally, if you remember doing consent agreements, it's probation, it's stage suspension, there's, requirements that he comply with the law and stay renewed, keeps his license up to date, that he's responsible for the costs of compliance. There are a lot of different factors that go into those kind of probationary terms. So if you think that you can come up with all the terms on the spot, then you could do that. Or you could table the matter and allow the state and Mr. Embrus to come up with a proposed order for the board. If you can just kind of telegraph what it is that you want in that order.
And that's what you usually do, right? So we come up with like some restriction to be added, and the state will work with responded to finalize it. I believe so.
I think that would be the better approach.
If I may, in those instances where your board counsel, myself or Ms. Franklin, we're working on behalf of the board with a respondent to draft a consent agreement. That happens frequently. Here, it's an administrative hearing. The parties are adverse to each other. So in my opinion, it would be Ms. Ray, working with board staff and Mr. Embrus to come up with an agreement, because we are adverse at the moment.
That does make sense.
And I believe that with respect to any proposed consent agreement, Ms. Ray suggested that you hear from the state.
So Frank, or Mr. Thorwald, is that what you're thinking? Do you want to?
Yes, that's what I'm thinking.
So it sounds like Ms.
So,
Galvin.
the state would oppose anything other than a voluntary surrender of his license or a voluntary denial of his application for renewal or denial of his application for renewal. As Mr. Al-Nassif pointed out, that this goes beyond judgment. This is goes to character. The fact that he may not be allowed to go back into Sam's Club as the basis for not accepting accountability and personal responsibility by even attempting to make restitution, I think speaks volume. Whether or not he makes restitution or tried or went on the Sam's Club website to try to find out who he might contact. You have someone who is admittedly engaged in a years-long enterprise to deprive his employer of $15,000 to $20,000 that he used for his own benefit. And the state would oppose anything that would give Mr. Ambrose a state-sanctioned license to practice. Practicing a profession is a privilege and should be reserved only for those who are deserving and have demonstrated that they possess the conduct, the honesty, the character, and the good judgment to hold that license and be a member of a profession that you all regulate. Thank you.
Thank you, Ms. Galvin.
Despite the state's position, I still think that there should be a second opportunity. The alternative is if somebody is unable to work or do things, and I think the last 3 years of him working in this capacity has shown him at least some better direction in his life, and I think he should have the opportunity. And if we have the right alignment in all of this, we will give him the opportunity to move forward. Or if he goes back to these other ways, we will have the opportunity to take it away. But taking somebody, giving him the way to have livelihood, gives him also the opportunity to make a restitution. Without a good livelihood or without good income, you have no ability to do that anyway. That's my thoughts.
I have a question for our attorney. If this board today upholds the denial of this application, is there a time period in which the individual can reapply?
I'm not sure that time period. Is it 2 or 5 years?
If the board sees the denial as a revocation or surrender, it would be a 2-year minimum.
Mr. Breeze, are there any other positions in your pharmacy that don't require a pharmacy technician license that might be appropriate for Mr. Ambrose?
Unfortunately, no, not at this time. We don't. I mean, there's billing office and we outsource our drivers. Would it be about the only other thing? But no, not at this time.
Thank you.
I just have a question for, I'm sorry, I forgot your last name.
Breeze, B-R-E-E-S-E.
Okay, great. So when did he share the history with you? Upon hiring or last week or?
So as I said earlier, I wasn't the pick originally when Eric joined Safety Drugs, but he disclosed that to the former pick who's now moved on. But as soon as I took over about a year ago, I believe last May, he disclosed to me right away what was going on. Because every month he had to like renew his license and get the new one as this was going. And he did, let me know what happened and the reason why he was in this situation.
And does your company do a background check
We do.
for
yes.
employees?
Yeah. Upon hiring, like I said, I don't know, since there was nothing filed, I don't know what would show up on the background check. Our HR does that. And I wasn't involved in hiring Eric at the time, but yes, we do background checks and all that. So I'm assuming since nothing was filed, nothing did show up, but he did disclose right away.
Okay, thank you.
Which I know too, there's letters from the old pharmacist in charge, our owners. I know he didn't submit as evidence, but I personally know from our owners now, the letter that they wrote in support of Eric.
Okay.
Mr. Chair, may I propose something?
Sure.
Grasping the pulse of where the board members are having a discussion, maybe a potential order would be a state revocation with a 5-year probation, working at the current location that was stated on record here, and any change in employment from the current employment right here would have to require board appearance.
I would be good with that.
And we can ask also like pharmacy in charge a letter, like follow up every 6 months or.
We
3
can't put
months?
that in the order to have the licensee request that from the employer. But we can't force an employer
Yeah.
to write that because they're not under discipline.
I will make that my motion.
Need a second.
Board members,
Second.
got a first and a second. Any further discussion? All right, Dr. Gandhi, roll call, please.
Thank you, Mr. Chair. Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye, sorry.
Ms. Spark,
Aye.
Mr. Hogan,
Nay.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Nay.
Ayes have it, Mr. Chair.
Thank you. This concludes the proceeding. The board's decision will reduce to a written order, and thank you for attending today, Mr. Ambrose and Mr. Bruce.
Thank you.
Thank you.
And thank you, State. All right, moving on to tab 25. We are on to tab 25A. This is the time set for consideration of respondent settlement proposal in case number 26-0254 for Signature Formulations doing business as Sigform. Are the parties present?
Jean Galvin, Assistant Attorney General on behalf of the state.
Thank you, Ms. Galvin. Are the parties from Sigform on the line?
I don't see anyone online. Chair.
So, Ms. Ray, what's your recommendation on this?
There's the gentleman that's seated over there. Is he?
He's one of our state compliance officers.
I'm going to go ahead and introduce myself. Apologize for the delay. Steve Hyber, Compliance Officer.
Ram Kalaburi, Compliance Officer.
Jean Galvin, Assistant Attorney General. If I may, Mr. President, I have had some contact with representatives of Sigform. They have requested this informal settlement conference and conveyed to me that they wanted to participate. I don't know if it would be possible to reach out to them to see if they plan on attending, just because I have had communication with them.
But we haven't seen any sort of written proposal on what they're proposing. That, at least I have not in this board book.
I have not as well.
Okay. So should we just come back to this item then? All right. So board staff will reach out to the representatives of Sigform, and we will move on to tab 25B. So this is the time set for consideration of respondent settlement proposal in case number 25-0505 for Jared Carl Turley. Are the parties present?
Jean Galvin, Assistant Attorney General on behalf of the state, and Sarah Hicks, Assistant Attorney General on behalf of the state.
Randall Nice on behalf of Mr. Turley, who is also present.
It seems like you're muted.
Sorry. Yes. Sorry about that. Jared Turley.
Hi, Mr. Turley. And are you represented by counsel, the other gentleman?
I am. Yes.
Could you please introduce yourself for the record?
Me or the counsel? I'm sorry.
The attorney, please.
I'm sorry. Can you hear me?
Now we can.
Okay. I'm sorry about that. I didn't realize you couldn't hear me. I'm Randall Nice, counsel for Mr. Turley.
Thank you, Mr. Nice. So the board will now hear presentations and argument from the parties on respondent settlement proposal. As the party making the proposal, the respondent shall go first. The state will then have an opportunity to respond. Respondent will then be given time for a brief rebuttal. So the order of presentation is respondent's presentation / argument, the state's presentation and argument, and the respondent's rebuttal. So, respondent, Mr. Nice, would you like to start?
Yes. Thank you. I'd like to thank the board for having us here today.
Ms. Gaharian, can you please?
Okay. Thank you. I wanted to thank the board for allowing us to be here today and listening to our proposal. I'd like to thank you for your time. I'd like to start out by discussing how we got here. The original issue that brought Mr. Turley under a probation order occurred a little over 5 years ago. Essentially, Mr. Turley was diverting medication. He recognized there's an issue. He needed to get help. So he started that process. He self-reported to his employer, who reported to the board. Mr. Turley and the board then entered into a contract, a probation period, including a PAPA contract for drug monitoring and rehabilitation, things of that nature. It's undisputed that he successfully completed the terms of those probations for over 4 years, successfully drug screened, no issues. He was working as a pharmacist during this time very successfully. And I think that period is important. The state has kind of made reference to try and make this one long continuous incident when it's really not. It's 2 separate incidents with a stabilization period in between them. And so he successfully completed the terms of his probations for 4.5 years. Earlier last summer, he had a positive drug test. We want to start out by absolutely stating that Mr. Turley has not used meth or any illicit drugs such as that. We believe that there was a testing error. We've retained an expert who has begun the process of examining the testing procedures, and we believe that we will successfully, if this were to go to an administrative hearing, we would successfully contest the positive drug test for meth. Now, that being said, after the positive drug test, Mr. Turley did go through, he met with the medical review officer, he met with Dr. Decker for a fitness for practice interview, and the board is familiar with those results. And I'd like to start out because the state has kind of made an issue of some of the explanations Mr. Turley initially put forward for the positive drug test. And those are not efforts by him to evade accountability. When this positive test came up, Mr. Turley was shocked. He was at a complete loss as to how he had tested positive. He'd never used meth before. During the interview with the medical review officer, the MRO put forward some examples of environmental exposure, what that could be. Mr. Turley, kind of struggling for explanation, put forth some of those possibilities based on those examples, but he was really just groping in the dark. He never intended those to be adopted as absolute explanations for the drug test. But I think the bigger issue that kind of came up that we understand the board's concern during the fitness for practice was the use of dextromethorphan or DXM to kind of treat psychological problems he was dealing with at that time. I would note he was, under provider's knowledge, he's working with a therapist. He was being treated with Wellbutrin. The DXM was kind of a misguided attempt to help treat symptoms that were being manifested at the time. And we totally understand the board's concern regarding use of over-the-counter medicines during recovery, especially in this kind of nature. But the underlying issue that Mr. Turley was attempting to kind of go it alone to address these mental health and recovery issues. And that's what led to this situation where he was using DXM in connection with some prescribed medication. We now understand, and he now understands the importance of relying on professionals and his support system to address problems that come up. I would also there's been some kind of misstatements, and partly on myself, about the Benzodrex, which we think is tied into the positive drug test. The Benzodrex was being used solely by Mr. Turley to address congestive issues in connection with what it's sold for over the counter. So all that, and I'd like to, when it comes to the fitness to duty report, really draw the board's attention to page 11 of the report by Dr. Decker, and I'm going to read it. Quote, Mr. Turley is not irredeemable, and this is a normal part of addiction. Like a diabetic eating cake while still taking their insulin, Mr. Turley's behaviors are expected. The best solution is not disciplinary, but to improve the monitoring and treatment to further assist Mr. Turley in returning to fitness for duty. Then, once off of DXM and stable, we can impose disciplinary guardrails to prevent any substance use recidivism, end quote. Additionally, Jim Corrington, the PAPA substance abuse therapist, expressed a desire to assist Mr. Turley with recovery by extending the monitoring agreement or restarting it instead of revocation. That was on page 9. We understand, obviously, there's been this second drug positive test, which no doubt gives the board concern. We would expect at an administrative hearing to address that in the same manner as the first one. But I think the better path forward, in light of recommendations from Dr. Decker, from Mr. Corrington, would be to reach some sort of agreement where Mr. Turley enters into continued monitoring, continuing guardrails to ensure his successful recovery, and that he can be continue his profession as a pharmacist. We just like to note that Mr. Turley has been upfront with the board from the original issue. The fitness for duty report, he agreed he was not fit for duty. Very honest with Dr. Decker. He's seeking treatment and support through his therapist and the PAPA program, even though his license has gone into a suspended status. He's continued the monitoring. He's continued the work. We recognize the board's legitimate concerns about substance abuse in pharmacy. However, we would like to emphasize the current matter before the board does not involve the diversion of drugs. So with all this in mind, we would ask the board that rather than move straight for revocation, we reach some sort of agreement that can allow Mr. Turley to continue to get support, continue to be a professional, but at the same time address any concerns the board has about public safety. Mr. Turley is prepared to meet additional requirements the board feels is necessary to protect the public. And so that in mind, we're respectfully requesting, we understand that this is left out of the initial proposal, but we believe a fitness for duty a new fitness for duty evaluation is needed, given that the last one he was not fit for duty, and he recognized that. Once we have that, we would propose a 6-month suspension period, minimum suspension period, where Mr. Turley completes 6 continuous months of negative drug tests, and at that time he returned to a probationary status for a period of 4 years or so, with additional guardrails, so that the board can be satisfied that the public is being protected and Mr. Turley can continue to practice. And Mr. Turley, I believe you'll hear from him, would like to address the board.
One moment, Mr.
Hey.
Neese. We do have a question for you, Mr. Neese.
Yes.
Is it appropriate, counsel, for me to ask questions?
Sure.
Mr. Nice, you said that Mr. Turley, you believe that his lab results were inaccurate.
Yes.
And was any repeat testing done? Because in looking at, he receives hair and nail tests. Is that correct?
That's correct.
So if he felt like the labs were inaccurate, did he seek out testing to try and confirm that this was an inaccurate test?
He sought out the nail and hair testing after the positive urinalysis, which also showed positive. And I believe one of those was above the cutoff level.
So he tested positive multiple times on multiple tests and using multiple methods.
That's correct.
Okay, thank you.
All right, Mr. Turley, we can hear from you.
Yeah. So again, thank you guys for hearing this. I came to the board when this all started, actually against legal counsel in 2021, because I was indeed recognized the issues and wanted to get my life straightened out. And I realized I couldn't go on doing that in the dark. I needed there to be some accountability. So I came forward under no pressure. Nobody was aware of my situation. My work wasn't aware. They were pushing for me to accept a long-term position. My family wasn't aware. This was strictly internal motivation for me to come forward, because I recognize the need for there to be accountability and restitution. I was very my most recent job that I was in for 2 years, they did not express any concerns. I was attended well. I feel like I performed my duties to the best of my abilities, and was a good pharmacist in that time. The reason for the license being surrendered was strictly the failed drug screen. I have no idea how methamphetamine ended up in my system. All I know is that I've never used methamphetamine. Like I'm really frustrated and worried because of the fact that I have now failed 2 drug tests and I have no idea why. And my family is suffering and has been suffering for, years now. But I recognize I was making some dumb decisions with regards to kind of self-prescribing and that I'm in a monitoring program, and I need to even be more strict with how I go about treating some of my conditions and not just relying on my own knowledge and self. But I've never used methamphetamine. I don't know how it's gotten into my system twice. Like he said, there were excuses that were put out there that were just me grasping at straws, that were responses to things the MRO asked me initially and put forward as possible uses, ways I was exposed. I don't think any of them sound like they are actually reasonable. Those are not things I would have put forward on my own, because I don't think they're the case, and I have no idea how I ended up failing 2 tests for methamphetamine. But I've never used it. I've never been around other people who are using it. As far as I know, I've never been in the presence of it. And again, I'm absolutely willing to do whatever I need to in order to prove to the board that it is safe for me to practice law and support my family. But even if that requires me, when I'm practicing, getting tested every other day for 5 years or whatever, like I'm willing to do that. I'm in an IOP program right now, despite not not having used methamphetamine, because it was recommended by Papa and by my psychiatrist. They didn't feel the need to recommend inpatient, because I think that it's safe to say they believe that I wasn't actively using, despite the drug test. But ultimately, I'm willing to do whatever is necessary in order to make the board feel comfortable with this situation. But again, I want to stress that I'm not trying to claim that I've been perfect in this situation, especially given my history. I recognize the need for an addiction specialist now, which wasn't something I thought was necessary. But I put the guardrails in my life, and I have a good support system, and I just ask that you guys consider allowing me a way to still practice and support my family. And again, I greatly appreciate you hearing the case. So.
Thank you, Mr. Turley. We're now ready for the state's presentation and argument.
Good morning, members of the board. Jean Galvin, Assistant Attorney General. Just to kind of frame this issue, Mr. Turley was under a consent agreement. He did not successfully complete the terms of that consent agreement, because in year 4, he had a positive test. It was a UDS. It was a random UDS. It was tested and then confirmed for methamphetamine. As a result of that, he underwent a hair and nail follicle testing that occurred, a couple of weeks later, and those reports came back as positive for methamphetamine. And when an individual tests positive for those substances, those kinds of substances, those tests are always rerun again, and they're confirmed to ensure that the first result was appropriate and was conducted properly. And in July of 2025, that's what occurred. And then again, in March of 2026, he also had another UDS under which the results came back confirmed positive for methamphetamine. He was ordered at the request of Papa to undergo a hair test. As we know, the hair will reveal what has occurred, been ingested in terms of substances for a longer period of time. And that result of that hair test was returned, confirmed positive for methamphetamine. The state reminds you that the consent agreement that was entered into was initially for drug diversion. And to say that Mr. Turley just, called the board, self-reported is kind of a questionable claim, because CVS terminated him because of this diversion. And for the last 5 years, nearly 5 years, his license has either been on suspension, placed on probation, or voluntarily suspended. And he has not, under all those conditions, been able to maintain his sobriety. He's admitted to abusing and resuming use of DXM and Benzodrex, in the words of the Papa evaluator, in a misguided attempt to address other conditions that he was experiencing. He has requested this informal settlement conference. We hear today that he's in an IOP program, yet he has not acknowledged his addiction or to what substance that he's using, and denies that he has ever used methamphetamine. He states that a recovery, a relapse can occur when someone is on the recovery journey. And the state acknowledges that a relapse can occur during recovery. But that recognition does not require the state to prioritize a licensee's recovery over their duty to protect the public. There's clear evidence in this case that Mr. Turley is not safe to practice, and as the board, you have an obligation to act in the best interest of the public. And it's the state's position that nothing short of a voluntary surrender or a revocation is sufficient at this point. While the board understands recovery, wishes respondents success on their journey to recovery, that does not trump your obligation to ensure that the public is protected. We believe that Mr. Turley has been given more than one opportunity to show his dedication and his ability to remain true to his recovery, and he has failed to do that. And therefore, it's the state's position that yet another consent agreement where guardrails would be installed is not warranted at this time. It's the state's position that he needs to take another timeout, a longer timeout, get himself completely well, and then come back to the board, as the public should not be potentially subjected to paying the price for his, inability, unfortunate inability at this time to maintain sobriety.
Thank you, Ms. Galvin. Mr. Neese, would you like to provide any sort of rebuttal?
Sure, I'd like to just discuss a couple points that were made. The first is the initial report. CVS did make the report, but they made the report because Mr. Turley brought the issue to them and enrolled in PAPA and told them that this had happened. And, arguably, so yes, I guess that's my point. CVS did make the report, but it was because Mr. Turley initiated this whole process. And he's been upfront with the board in that aspect. The The issue of the use of DXM, that was identified by Dr. Decker in the Fitness for Duty report. Dr. Decker recommended tapering off. I would note that Mr. Turley stopped using it cold turkey. His current testing includes testing for the abuse of DXM, so that would show up if he's still using it. He has stopped. He's enrolled in the IOP currently, in part to help him with tools to address issues that come up in response to, obviously certain mental health issues and having previously suffered from addiction. And currently they're focusing on issues like the use of, caffeine, nicotine, substances like that to try and deal with, what problems Mr. Turley may face. And so the IOP is really there to help give them tools to continue to be successful in regards to addressing, mental health and addiction issues. One sec. And we acknowledge obviously there were the positive results, which Mr. Turley is at a loss to explain. We have, like I said, retained expert we believe will be very convincing at the before the administrative judge, especially in light of the fact that, and he'll testify about the procedures used in this case, and where there were deficiencies and how problems could arise, especially with somebody who's taking something like Wellbutrin or Benzodrex, which can cause problems. And he did, I would note that he submitted to the nail testing and the hair testing on the initial positive. The nail testing was below the screening limit, whereas the hair testing was just slightly above the limit. Obviously, we still don't know how that happened. Well, let me rephrase that. Mr. Turley did not use meth, and we believe that could potentially help explain this positive drug test in light of the substances Mr. Turley was lawfully using and the way the testing was submitted. And we would just really kind of drill down to, we understand the state's position that the board has to prioritize public safety, and we believe that can be done without revoking Mr. Turley's license. Both Dr. Decker and Mr. Corrington in their reports were in agreement with that, and we would ask that the board adopt that course of action.
Thank you, Mr. Neese. Having reviewed the information submitted by the parties and heard the presentation and arguments of the parties, the board will now deliberate. There will be no further comment from the parties while the board deliberate. So the floor is now open for board members for discussion.
I'm in belief we should revoke the license. My time working at the Justice Department and afterwards, you can have some tests that's certainly they can be errors, but multiple tests, the likelihood we're more likely to have a meteorite come in and hit us right now and it'll kill us than multiple tests failing like that. And some miraculous genie dropping something in a person's system, I just don't believe in that. So I'm for the revocation.
So it looks like there's three potential motions for us: to accept the respondent settlement as proposed, to reject the respondent settlement proposal, or to offer an alternative settlement proposal.
I move we reject the proposal.
And the matter will proceed to formal hearing?
And the matter will proceed to formal hearing.
Second.
Any further discussion? All right, all in favor, please say aye. Oh, sorry. Dr. Gandhi, roll call.
Mr. Thorwald.
Aye.
Ms. Browning.
Nay.
Ms. Davis.
Aye.
Ms. Walmsley,
Aye.
Ms. Park,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Mr. Chair.
Thank you, Dr. Gandhi. Thank you, Mr. Turley, Mr. Neese for being here, Ms. Galvin, Ms. Hicks for being here, and your board staff will be in touch.
Thank you.
And how's
Can we take a break 10 minutes?
yeah, we'll take a 10 break. All right, welcome back from break, and we will move back to 25A. I understand that the representatives from SIGFORM are now online.
They are, Mr. Chair, yes.
Great, wonderful. This is the time set for a consideration of respondent settlement proposal in case number 26-0254 for Signature Formulations DBA SIGFORM. Are the parties present?
Hi, yes, Ms. Maria, right here present. And we should also have Raul on the line.
Mario, what was your last name, sir?
Mexia Esparza.
Okay, and do you have a camera you can activate for us?
No, not on this device. I can't access the camera.
Okay, and who's the other?
It should be Raul Garcia. He should be under SIGFORM.
Mr. Garcia, could you please unmute yourself, turn on your camera if you can, and please introduce yourself for the record? Mr. Garcia, are you there?
I sent him a request to unmute, but it doesn't look like.
Yeah, we can proceed. I'm not sure why he's not responding.
All right. Thank you, Mario. Would the state please identify yourself for the record?
Jean Galvin, Assistant Attorney General on behalf of the state.
Thank you. The board will now hear presentations and argument from the parties on respondent settlement proposal. As the party making the proposal, the respondent, SIGFORM, shall go first. The state will then have an opportunity to respond. The respondent will then be given a time for a brief rebuttal. So the order of the presentation will be respondent's presentation and argument, state's presentation and argument, and then respondent's rebuttal. So we'll start with SIGFORM. Could you please, your floor is yours to present your argument.
Yeah, so my understanding is that we didn't show up December for a meeting. Also, some repeat violations, 5 which are repeat. One of those being the water system, no proper procedures, among other things. And we have been the past month doing a lot of management changes, proper quality control personnel, as well as overhauling the whole water system that we've been using. We've changed many other suppliers and different forms of testing as well.
Y no ha salido bien.
And it looks like SIGFORM, is this Mr. Garcia speaking now?
Yeah, this is Raul Garcia.
Mr. Garcia, could you please introduce yourself for the record?
Yes, my name is Raul Garcia. I'm working right now as production manager, but taking helping the company to do our QC management.
Thank you, Mr. Garcia. Was that your presentation, Mario? Was that your argument? Are you done presenting?
Yeah, it was just we've been doing a lot of changes right there. We've had new personnel come in. We're in the search right now of a quality control person. The one we had previously was not in the company's best interests. I believe he was doing more harm. He was jeopardizing us. So we let people go that weren't helping. We're bringing in new people. Like I said, we've improved our water system that we've failed multiple times. And yeah, I mean, that's what we have right now. That's our presentation.
So Mario, what is your specific settlement proposal?
Obviously, we like to keep our permit. I'm not sure what we could do to prove if there's maybe we get an extension or have people come in so they could see the improvements. We just say from we like to keep the permit, but as well show proof that we've upped our standards, upped our quality, and made it a lot more safer for everyone.
Thank you. States, now we'll hear from the state, please.
Briefly, members of the board, Jean Galvin on behalf of the state. I too am curious because we have not seen anything in writing. It appears that only once the notice of hearing went out, which is within the last month, that they started to make the changes. These were repeat violations. The quality control person that they hired, they improved a water system that has failed multiple times, but yet we just got to it within the last month. And they're making changes in personnel. I would ask that you speak with the compliance officers. I haven't seen any evidence of these changes that they have made in the last month for improvement. So it's a little hard to gauge the extent or whether these changes and improvements have been made. And I don't know if, Ram or Steve have any.
This is Ram Kalapudi, Compliance Officer with Arizona State Board of Pharmacy. I reviewed the renewal permit application and also all the FDA observations, 483s and all that. And they received a warning letter after our meeting in December. I'll give you a brief summary that encompasses the FDA warning letter items, if you permit. Shall I proceed? So FDA issued a previous warning letter in July 31st, 2018, and most recent warning letter was issued on January 21st, 2026, citing similar CGMP violations. The FDA core findings center on inadequate oversight of quality unit. The FDA cited the use of an unvalidated water system in manufacturing and failure to conduct required chemical microbiological release testing. SIGFARM doesn't want to do objectionable microorganism testing, so FDA didn't like that because they do compound products. I mean, they do manufacture products for kids, mouthwashes, like that, toothpaste, things. And also they use a BioEst topical estrogen product. So FDA position is they should do objectionable microorganism tests, but SIGFARM didn't want to do that, at the time of inspection, and also when they responded to the 483. So warning letter is issued when 483 responses were inadequate. So they received the warning letter in January. So most critically, hormone-containing products share equipment and space with children's oral care products, creating a possible cross-contamination risk that the FDA has required to be addressed through a full risk assessment and a validated cleaning program. A batch record review revealed alarming documentation and formulation failures, a 11-fold retinyl palmitate overdose, and 50% excess of copper sulfate in children's mouthwash, and pre-recorded pH pass results, that is a bad documentation practice, use of lab grade instead of pharmaceutical grade components, industrial grade cleaning solvent, and no component identity testing either. They just rely on the manufacturer supplier COA on the components. They don't do any identity test or end product testing either. And SIGFARM's consistent position that it is a cosmetic dietary supplement manufacturer and therefore not subject to drug CGMP requirements was rejected by FDA, which directed the company to retain qualified drug law and CGMP consultants. So I'm not sure whether they hired anyone in the quality unit to oversee the processes or consultant to rectify the problems.
Thank you, Mr. Karlapudi. Mr. Hyper?
Yeah, I'll just add, I am the compliance officer for this facility. I always have been, I currently am. And I did my last inspection of the facility on July 1st of 2025. Violation was issued 21 CFR 111. And it was basically, they didn't have a quality assurance individual, or at least someone that was qualified to perform those quality assurance activities. And that was my concern, having been privy to the previous 483 and warning letters issued by the FDA. I recognize that that might be some of the problems, the unqualified water system, so on and so forth. They didn't have appropriate quality individual running the operation. And what I find most interesting is on their October 2nd renewal of their permit, which was done online. So it wasn't done by anyone in our office, or our name would have been on it, created by. On October 2nd, they indicated that their quality assurance person, Damian Thomas, had ended his relationship with the firm on October 1st of 2025, and that Raul Garcia took over on that same day, 10/1/25, which is interesting because on July 1st, when I was there visiting doing the inspection, I was informed that Raul Garcia was the quality assurance individual because Mr. Thomas had already left and they were having difficulties finding a replacement. So Mr. Garcia stepped in as quality assurance individual. So I think we've got some incorrect information on their permit renewal, as well as to still not having, at least as my knowledge today, that they have a qualified quality assurance person in that operation currently.
Thank you, Mr. Hyber. Mario, we can go back to you for any sort of rebuttal or any sort of comments to what the state has presented.
Yes, there's a few points. With the quality assurance person, we have one we just hired week and a half ago. We're actively working with that person to bring them up to date with everything that's been going on, presented previous forms. We have Raul is actually helping the experience. Like I said, Dave no longer working there as he was not putting the company at its best interests. With the previous violations, we have, I think someone had mentioned earlier, the first point, we have documentation of two companies that came with a company the past month with different types of testings. I'm not sure, maybe that's something we could send to the board to show proof of certain improvements. But with the quality person, we had just hired someone a week and a half ago and are bringing him up to date with everything that's been going on, and actively trying to help or trying to improve these past observations.
Mr. President.
Thank you, Mario.
The FDA required them to hire a consultant because we are not experts in everything. So I suggest recommending a consultant to clean up the process.
Thank you, Mr. Carlapudi. All right. Having reviewed the information submitted by the parties and heard the presentation and arguments of the parties, the board will now deliberate. There will be no further comment from the parties while the board deliberates. And the floor is now open for deliberation and discussion.
I have some real serious concerns here. I'd like to lay them out. First of all, regarding the permit holders' responses, they missed the December meeting. They missed the earlier time this morning. We actually had to reach out to them. They have no written corrective action proposal that I have seen. It appears that they're in a deep transition period in trying to correct a number of issues. We learned today also that there was a new FDA warning letter issued on 1/21/26. And typically a warning letter occurs because there hasn't been proper follow-up to previous inspections. I have some real concerns here, and I'd like to hear some other comments if there are any. Otherwise, I'm ready to make a motion.
Yes.
No, Mario, we're in deliberation phase, so there's no more comments from the respondent or the state at the moment. So this is for the board members to discuss. Mr. Hogan, hearing none, I think a motion seems appropriate at this time.
Move to reject the permit holder settlement offer.
I second.
And the matter will proceed to formal hearing?
And the matter will proceed to formal hearing. I'll add that to my motion.
Yeah.
All right, we've got a first and a second to reject the respondent settlement proposal and move and proceed to formal hearing. Any additional discussion? Dr. Gandhi, roll call, please.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Mr. Chair.
Thank you, Mario. Thank you, Mr. Garcia, for being here. Staff will be in touch. And moving on to the next tab, an item on the agenda is 20B. Pull that up. This is a renewal application for Brett Charles Regal. Hi, Mr. Regal. Could you please introduce yourself for the record? And
Brett Regal.
Thank you.
Good morning, and Michael Rain on behalf of Brett Regal.
Thank you, Mr. Rain. And we have Ms. Mitchell, board staff. Would you please provide a summary for us, please?
Certainly. Brett Charles Regal was licensed as a pharmacist on December 23rd, 2021. He applied for the renewal of his license on October 19th, 2025. He disclosed an arrest for DUI on his application. On February 12th, 2026, the board considered Mr. Regal's renewal application. After review and discussion, the board decided to postpone consideration of the application until staff received additional information relating to his criminal case, to include the results of the blood testing completed by the police. Mr. Regal's counsel, Michael Rain, provided the results of the blood testing that afternoon. I'm echoing. On April 20th, 2026, staff received an email from Mr. Rain stating that Mr. Regal's criminal case had been resolved. The documents he provided indicated that Mr. Regal pled guilty to DUI drug. And that's all I have.
Thank you, Ms. Mitchell. And Mr. Rain, would you like to make a statement before we move into questions?
Yeah, only briefly. We appreciate the board's time. As a small point of clarification, Mr. Regal first disclosed his arrest within the 10 days that the law requires. He's subsequently, I believe, disclosed it on a renewal. He also disclosed the conviction when that occurred within the deadline. And he's cooperated with the board, including volunteering himself for the drug testing that the board ultimately had to order so that we could get it because the testing facilities required an order. And so we believe the record is complete. We're not aware of any further board investigation. This matter, as you've heard, has been pending for, it's starting to approach a year. The board typically resolves first-time DUI misdemeanors without discipline in certain types of cases. Of course, every case is different and you look at the facts, but we're aware of no aggravating factors in this case that should result in a different outcome. But our other main request is that we try to resolve this case today if we can with a final decision, but at minimum to finally renew Mr. Regal's license so that isn't at least hanging over his head any longer. But we are here today to answer any questions you have to help promote that. And we look forward to the discussion if you need any.
Thank you, Mr. Rain. Board members, the floor is open for discussion. Mr. Rain, I know we were actively working with you and the criminal attorney to try to get the testing for the 2 vials that were obtained and impounded. And it seems like we've been unsuccessful in getting any results of what's in these vials.
Yeah, and Brett maybe could supplement, but I attempted to contact the criminal defense attorney without success on that. And I inquired with Mr. Regal, and I guess it was my understanding it was just silence about that. There was no answer one way or the other. We know it was spent for testing. We'd be happy to get those results because of his position. It was saline that we talked with you. But is there anything more that I'm missing about the vials?
I reached out as well and no response. But if you want to swear me in, I'll swear in it was saline.
Thank you, Mr. Regal. Any board members, any discussion or somebody considering a motion?
So Mrs. Mitchell, now we just, so it's a renewal application, correct?
That's correct. Yes.
And pending this situation, correct, to be resolved. So what I'm thinking to accept the renewal with put on kind of like probation monitoring program, I don't know. So do you have proposal, like, because I believe, as I remember last time, you've been talking about like proposal, like you.
Our proposal is dismissal because there's no violation.
Okay.
It is not grounds for discipline to have a misdemeanor, and we have no allegation even of ongoing impairments.
So it is a DUI case, right? And he disclosed it, correct?
He disclosed and then disclosed again on his renewal. There technically is no complaint. So it's just the renewal application to consider whether to approve or not.
So I feel comfortable if this is, and I move to approve his application.
I'd second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Thank you.
All right. Next item on the agenda is 21E. This is pharmacy technician trainee registration, Desiree Cook. Is Ms. Cook available? Wonderful. Hi, Ms. Cook. If you could please activate the microphone and introduce yourself for the record, please.
Desiree Cook, hi.
Hi, Ms. Cook. And we have Ms. Castro. Would you like to share a summary for us, please?
Sure. Christina Castro, licensing administrator. Desiree Cook applied for a pharmacy technician trainee registration on March 10th, 2026. During the review of the application, it was found that she was arrested and charged with 2 DUIs, endangerment, and criminal damage between January 2020 and September 2021. On January 25th, 2020, Ms. Cook was stopped by police for multiple traffic violations. When the officers approached the vehicle, they smelled a strong odor of alcohol. A preliminary breath test showed a BAC of 0.237. Ms. Cook was subsequently arrested for driving under the influence. On September 17, 2020, Ms. Cook was stopped for failing to obey traffic signs that said no U-turns. Officers discovered Ms. Cook's driver's license has been suspended as a result of the January 2020 DUI, and she had failed to install a required ignition interlock device in her vehicle. A preliminary breath test showed a BAC of 0.172. Ms. Cook was subsequently charged for two felony counts of aggravated DUI. On September 20th, 2021, Ms. Cook was cited for driving without a license, unsafe lane change, and criminal damage defacing property when she stopped at a traffic light and exited her vehicle and spray painted a traffic barricade. On April 23rd, 2023, Ms. Cook's September 2020 DUI was adjudicated. She pleaded guilty to 1 count of endangerment and a Class 6 designated felony and 1 count of DUI liquors, drug, vapors combo. She was sentenced to 30 days in jail and was ordered to install an ignition interlock device on her vehicle, pay fines, and complete substance abuse treatment classes and serve 3 years of supervised probation. Ms. Cook completed the terms of her probation on in April 2026. She is still making payments on her fine.
Thank you, Ms. Castro. Ms. Cook, would you like to make a statement before we move forward with questions?
I just want to thank you all for being here and seeing me, and also that I just want to say that I'm hoping and looking forward to get the training license, because I have made a lot of changes and better decisions, and I look forward to moving on with my life and doing better things, and also being a pharmacy tech would be cool, because I've always wanted to do this, and yeah, that's it.
Thank you, Ms. Cook. Board members, the floor is open for discussion and questions.
What do you do now? What do you work?
Right now, I am a custodian for the Gila River Indian community. I've been there going to be 3 years November.
Ms. Castro, were these disclosed on the application?
She would apply for a training registration. The questions are not on.
So this is still the function of the application not being live in the online system?
That's correct. The online application has not yet been updated to ask those regulatory questions. The board's licensing database vendor is working to make that live.
So you just discovered this through your due diligence, Ms. Castro?
Yes.
And Ms. Cook was eventually charged and convicted of misdemeanor DUI. The other felony charge was unrelated to the DUI.
Yes. She was plead guilty to 1 count of endangerment, a class 6 designated felony, and 1 count of DUI liquor. Yeah.
So Ms. Castro, you went through, a substance abuse treatment course as a condition of your, criminal conduct. Tell us about that. Are you working a program today to stay sober, or what's that look like?
My last name is Cook, and I've complied with everything that I was supposed to do, which was I've done my interlock, I've done my probation, substance abuse, I've done all of that alcohol screening and all that. So I'm done with basically everything, and right now I'm just working and waiting for this to be approved or denied to have a training license. So, and to this day, if you're talking about my sobriety, I'm been sober and clean and just taking care of myself and my life, my kids, family.
What's your sobriety date?
As of June 2023.
Okay, thank you. Anybody ready for a motion?
Do you have a job offer or just you want to apply?
Right now, so right now I'm on LOA because of this, and I applied for Carrington College, and that's what they're waiting for is this. So to be on
So you want to go to school
Yeah.
to be a pharmacy technician, not just to work. Okay. I'm totally fine with that, and I move to approve her application.
Second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you, Ms. Cook, for being here.
You.
All right, the next items on the agenda are 26D and 26E. And are we taking these together, Ms. Galvin?
going to steal the chair, so absolutely. Thank you.
Hi, Ms. Trujillo. Could you please introduce yourself and the parties for the record, please?
Good morning, Mr. President, board members. Susan Trujillo from Quarles and Brady, and with me I have Christina Bonillas and Nathan Wenger.
Thank you. And we've got Ms. Mitchell. Would you care to share a brief summary for us, please?
Certainly. On February 12th, 2026, the board considered case number 24-0569 involving Christina Bonillas and Nathan Samuel Wenger in conference. After review and discussion, the board decided to offer Ms. Bonillas and Mr. Wenger consent agreements for probation with disciplinary continuing education to resolve the matter. On February 27th, board staff sent Ms. Bonillas and Mr. Wenger and their attorneys proposed consent agreements for their consideration. On March 13th, 2026, Ms. Trujillo with Quarles and Brady submitted a request for reconsideration of the terms of the consent agreements along with redlined consent agreements for the board's consideration.
Thank you, Ms. Mitchell. Ms. Trujillo, would you like to make a statement before we move into questions?
Yes, please. Nathan and Christina are here today to ask the board, as Ms. Mitchell said, to reconsider the prohibition on them serving as pharmacists in charge during the timeframe of their probation. They understand this is a standard term for probation, but they think that the circumstances in this case argue against imposition of that particular restriction. Probation is imposed to protect the public health and safety and rehabilitate or educate the licensees concerned. And while Christina and Nathan understand that the board's concerns regarding the facts of this case, the PIC restriction won't serve those stated purposes. The prescriptions in this case were dispensed in May of 2024, and there's no evidence that these pharmacists present an ongoing risk to the public health and safety of Arizona citizens so that a PIC restriction is necessary. There's also no evidence that the PIC restriction would rehabilitate these pharmacists as they've been practicing without incident since these matters occurred in 2024. Finally, there's no evidence that the PIC restriction would further educate them on controlled substance dispensing. They've already taken additional CE in controlled substance dispensing and are required to take another 3 hours of CE in pharmacy law under the proposed consent agreement. So regardless of all of this, they're willing to enter into the consent agreement for probation, but they're simply asking that the PIC restriction be removed from the consent agreement because they don't pose further risk to public health and safety, and the restriction would not serve those purposes. They have accepted responsibility for their actions. They provided written and oral evidence to the board regarding how they worked through the red flags that were raised during the dispensing of these prescriptions and how they used their professional judgment to evaluate each and decide to dispense the prescriptions. Unfortunately, they were victims of the same fraudulent actor who convinced pharmacists at 2 other Arizona pharmacies to dispense medications to this prescriber. Pharmacists, it does not appear the board has taken action against. The imposition of the PIC restriction will also cause challenges not only to these pharmacists, but for the pharmacies in the community that they serve. Though Tucson is the second largest city in Arizona, they've seen their employers find it challenging to staff PIC positions in the area. At Ms. Bonillas' pharmacy, the staff pharmacist is unwilling to take the PIC position for more than 6 months, and the proposed term of probation is 2 years. So the pharmacy would be forced to open the position to a search. This would mean that once one can be identified, a brand new PIC would join the pharmacy who doesn't have the same relationship with the patients and the prescribers in that neighborhood. Mr. Wenger's pharmacy is similarly situated. A PIC change and the domino effect it may have in the area could cause his location and potentially other locations to be less successful and decrease patient safety because other capable pharmacists would be removed from locations where they've already developed relationships with their practitioners and nearby and patients. Christina and Nathan have learned valuable lessons that could be shared with pharmacists and pharmacy students throughout the state. And they're willing to offer that as a condition of their probation, they'll reach out to Midwestern and the University of Arizona Schools of Pharmacy to offer to speak with pharmacy students about their experience and what they've learned. They'd also offer to share this experience and lessons learned with their colleagues in a manner that works for their employers. As Ms. Mitchell noted, draft consent agreements that memorialize all of this and other edits for the board's consideration were submitted with the request. Christina would also like to note for the board's consideration that her involvement with these prescriptions was far more limited than Nathan's. She was the pharmacist of record only for about 1/3 of the prescriptions that were dispensed on the first day of these matters, and she didn't work on the 3 other days when those other prescriptions were dispensed. So she asked the board to take this into consideration when it considers this request.
Thank you, Mr. Trujillo. Board members, the floor is now open for questions and discussion.
So I don't have a motion now, but this is some thoughts. So this is what I call lack of judgment happened for like, it's not like malicious. As I remember the case, it wasn't, there is no relations between providers and pharmacists in this case. It's totally lack of judgment. And from my perspective, I've been thinking about this, to be honest. And then when I signed the agenda, I said, okay, great. This is opportunity to voice my thoughts here. Specifically to a pharmacist in charge position, that this position, everything held again, I mean, on those managers. To me, in this case, I have never seen like their action wasn't like malicious or lack of law knowledge. It is lack of judgment there. I mean, absolutely, I'm not gonna deny there is many red flags they should have take a look at and stop them. But can they be a pick or not? That's a question. I mean, me personally, I don't see issue where any of them be a manager actually that can teach this. I mean, this is gonna be taken with them all their career and teach others pharmacists.
Yeah, Mr. Al-Nassif, I tend to agree with you. I think, given, what we know, the numbers of, the prescriptions that, and the multiple red flags that could have been is concerning. But I agree. I think it's a judgment issue, and not necessarily something that is of, oversight necessarily that the PIC would be expected to have. So I have yeah,
Correct.
I agree with you. I just don't know if that's something that we've done before, to
It's
alter the terms of.
I know notice that Dr. Gandhi can see if there's any similar cases, but I don't see a diversion there in
Yeah,
this case.
correct. I agree.
And I don't see, it is lack of judgment. And when you get like in this kind of a scam, it will continue, right? Like the same provider for like few days, correct? Or like more prescriptions. Now, they will do the same mistake even they are a pick or not, because they don't need a pick approval for that, right? Like, I mean, moving them from pharmacy in charge to a staff pharmacist, as the lawyer mentioned, like, you're not protecting public, because they're not bad pharmacists. I mean, they are good pharmacists. I mean, they are pharmacists, right? So being a pick is not gonna cause any harm to public. That's how I see it.
So there are other red lines in the proposed document that Mr. Trujillo submitted. So if we were to just take out the probation or just take out the PIC, I think I could get on board. But the other red lines, I think I am concerned with all the red lines that you have in that document.
So yeah, so we can discuss them one by one. So, but that is just regarding the being pharmacist in charge. That's my thoughts about this.
If I remember, you guys worked at the same store, right? Do you continue to work at the same store? Okay.
It's me now.
No.
Are you both PICs just at two separate locations then?
Yes. Yes.
Mr. Anderson, what are your other concerns on the red lines that you saw?
There's a lot of different language changes, and unfortunately, I'm not able to pull it up on my
I'm
computer
sure
at the moment.
Okay.
And if I may, board members, a lot of the changes were in the findings of facts section where there were facts that were alleged that weren't supported in the board materials, such as in the DEA investigative report. So we made those changes to align with what's in the investigation report. I mean, if at all helpful, we can take that piece of the discussion offline. I don't know that you want to go through redlining a consent agreement live here. We can take that offline, and I can work with Dr. Gandhi and his staff on the pieces of the consent agreement. But it's helpful, but if we know that we'll, kind of continue to move forward,
So-
based on the discussion here, we can do so.
For the first one, so generally, anybody on probation, we ask them to request termination request termination from probation and come to us. You've redlined this and say automatic terminate 24 months from the beginning of the period of probation. Why is this a special case, and why would they not come in front of us like everybody else?
Certainly, and I think this is just these are pharmacists that work in Tucson. So and it sounds like there's discussion here that this isn't a diversion case. The probation is being imposed simply to reflect the lack of judgment. But if that's a deal breaker for the board, we can certainly remove that request. But there are, oh, please.
No, I do like the University of Arizona and Midwestern offer to present. I think if we could make that a little bit more firm and not just offer to present, but actually do this, for each school year, so that the probation is 2 years, and you actually do this and submit evidence that you did present to both colleges of pharmacy. I think that would be a little better good faith than just the offer to present.
Of course, and the reason that I use that language is simply that I can't command the U of A to have them come in and teach the class. So we're happy to work with your contacts and with our own at U of A and Midwestern to
sure.
try and push this forward. It's just simply that I can't commit them to that.
And I'm sure their pharmacy law and ethics course facilitator would welcome them.
Dr. Gandhi, well, let me just start by saying I would hate for this case to have to come back to a future board meeting because we were unable to resolve some of these red line issues. In your initial review, Dr. Gandhi, do you see anything in the red lines that you feel you'd be, and I know this is speculation, but that would be hard for you to really figure out? I mean, I know you're really good at your job and you can probably figure it all out, but the board has some concerns with some of these.
No, absolutely. And the findings of facts, Ms. Trujillo and I can work those out. I feel confident that we'll get there. I think the meat and potatoes of this is the PIC component and then the presentation. If you can shore that up, the rest of it we can figure out.
I agree.
Agree.
So the motion will be like to approve the request to remove the being pharmacist in charge from the agreement
Approve their request and allow the
and allow
executive
them to
director
work with
to.
our, and this is my motion.
So, sorry, if there's a second.
I second.
So just point of clarification is the PIC components being addressed, the presentations to the colleges, and then they still have to appear to lift the probation.
Correct. No automatic termination.
Okay.
I have a point of discussion. So if I recall correctly, at the meeting, the last board meeting, the respondents argued that their process of addressing the red flags was reasonable. And that concerns me to a certain extent because the PIC is a position of authority, and it may not be a position of authority in all areas, but it is nonetheless a position of authority. And my concern would be that the respondents would provide inappropriate advice based on their experience in this case to other pharmacists. And so I just wanted to make that comment.
May I respond to that?
Yes, please.
Thank you. I believe the testimony from the respondents was that what they did was reasonable based on the facts in front of them. And unfortunately, this person was lying to them top to bottom. So I understand your concerns. And certainly they've learned from this experience. And I do think this will make them more powerful picks. But yeah, I think that was the reasonableness of this was, at that moment with the person standing in front of them and the information that they had, they thought what they were doing was reasonable. Yeah, they would have made a different decision, if all of those, if they hadn't run all of that through their professional judgment and reached the decision that they did, if those facts didn't align.
Thank you.
And the preceptor provision, is that still in there? Where they can't be preceptor?
That is still in
Okay.
there. It's just a PIC component that was up for debate.
Now, when we talking about preceptor, if they have an employee as an intern, that would consider precepting, like not as a rotation, as like employment.
Yeah,
intern.
if they're the pharmacist overseeing a licensed intern, that's a preceptor.
Yeah, just to make sure. So,
And do you do that in your positions? I didn't understand that you served I thought you didn't serve as a preceptor for any of your positions.
No, I don't currently serve as preceptor. I was interested in doing it because the U of A sent me an invite, but I never responded because I don't know what was going to happen here.
And again, my knowledge of being a preceptor would be more towards rotation-based students, whether it's going to be advanced or in the beginning stages of their education. If I have an intern employed within my pharmacy, though, would that prohibit me from being or overlapping shifts together?
If you're the only pharmacist on duty, yes.
I would.
No.
Is it like Dr. Kennedy, like if about the preceptor part? So if they have intern employee, not part of the rotation from the college, as employment, I know they work under pharmacy supervision, but if there cannot be a preceptor, they cannot supervise them.
If they're an employee of the pharmacy, they're an employee of the pharmacy. That's not necessarily, you're not serving as a preceptor at that point. So, yes.
So an intern who's working at this pharmacy, an employed intern.
That's a gray area. Mr. Chair.
Exactly.
Because Dr. Anderson, the reason why years ago we used to have approval from the board to be preceptor, they used to send a kind of certificate, or I forgot, right? And then this is not valid anymore. So, but the supervisor pharmacist is different than the preceptors.
But they're still mentoring an intern while they're under their supervision, whether or not
Supervision is
it's
not
part of a
prescriptive.
didactic or, experiential program through an accredited college of pharmacy, it's still, you're providing that supervision and mentorship, which is, I would envision that a preceptor.
So when employer rotate their interns and the PIC doesn't know they have an intern coming. And this is really like, to me,
That's
like
a
it's
PIC problem. They should know if they have an intern, if
it's a
they have an
PIC problem if they do the schedule, but this is like, we can discuss it offline, but.
I mean, just another thought that I have though, and I agree with leaving the preceptor portion in because I feel like the intent is to, not have interns on rotation through colleges of
Correct.
pharmacy.
Yeah,
I
yeah.
think that's the intent.
Correct.
We're also asking and requiring that they reach out and present to students
Yeah.
regarding this case. So I think this is also a teaching moment too. So just to put that comment out.
That's a good point.
All right, we've got a first and a second. Any further discussion? Great discussion, everyone. All right, Dr. Gandhi, roll call.
Thank you, Mr. Chair. Mr. Thorwald.
Nay.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Swansky's recused, Ms. Spark,
Aye.
Mr. Hogan,
Nay. Nay.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Mr. Chair.
Thank you. Thank you for being here.
Thank you.
All right, next on the agenda is 26F. So this is discussion, consideration, and possible action regarding the request made by Dharma Research for the reconsideration of the board's decision to deny its manufacturer permit application. And it looks like we have Mr. Snyder here. Could you please introduce yourself for the record?
Yes, Alex Snyder with Quarles and Brady, counsel for Dharma Research.
Thank you. Could you please introduce yourself?
Yes, my name is Ricardo Carles, and I am the president of Dharma Research.
Thank you. Ricardo, what was your last name?
Carles, C-A-R-L-E-S.
All right, thank you very much.
Steve Hyber, Compliance Officer.
Thank you very much. All right, Mr. Hyber, would you please share a brief summary with us?
Be happy to. This complaint was opened at the request of the board back at the April board meeting this past April. And it came up during the issue involved came up during review of another complaint 260081. So we found that Dharma Research out of Miami, Florida, they applied for this permit back in August of 2025. And the applicant did disclose some previous discipline imposed by the state of Florida back in 21 involving a fine of $25,000. The violations involved a failure to deliver a compliant transaction history, operating without a permit, selling prescription drugs to individuals not authorized to receive prescription drugs, and purchasing prescription drugs from persons not authorized to sell prescription drugs. So when we see that again, as I stated before, we request information, and we were able to get information about their distributions in Arizona that may have occurred prior to them receiving a permit. And we found a total of 33,386 drug products were shipped into Arizona before even applying for a permit. And that information, if you're looking for details, about page 5486. We also did receive a communication from council just a few days ago, back on June 16th, and that's been put in the front of the actual summary that I just provided, starting on page 5477. This firm, during the initial investigation of that last complaint, they had asked to withdraw this permit, and then I think they reversed direction in that regard, and that's what the council, documentation on that page is requesting.
Thank you, Mr. Hyber. Mr. Snyder?
Yes. First of all, I just want to thank the board for accepting this request for reconsideration. In particular, Dharma Research seeks reconsideration of the denial of the application and wishes to proceed with their non-resident permit. We acknowledge and agree with everything that Mr. Hyber has said, that the broad language under Arizona law requires a non-resident permit to ship 1.1% sodium fluoride toothpaste, despite its kind of unique FDA designation. And committed to working with the board to come to some sort of resolution to move forward. So these dental prescription toothpastes have an FDA designation as an unapproved drug other, which means that they do not go through the formal FDA approval process. There's kind of a unique gray area that they operate in. During this time period, they completed 6 total shipments in roughly a year period, 3 to True Marker and 3 to IPG, which I believe are active, essentially the same entity, but there was a permit change and an ownership change or something along those lines that resulted in that. I believe that was discussed in the previous board meeting by Mr. Hyber. Dharma became aware that the permit was required and immediately filed for an application with the board. Shortly thereafter, the relationship with True Marker IPG dissolved, which led Dharma Research to believe that they no longer needed a permit. There was no longer any business opportunities in the state of Arizona, which led to the original decision to withdraw. the application. But after some internal discussions from a business perspective and internal discussions with us as their legal counsel, we understand the ramifications of what a denial of an application really looks like. And Dharma now seeks to maintain a non-resident Arizona permit moving forward and to work with the board moving forward to try to come to some sort of resolution. Now, Mr. Carlos has a short statement he would like to say, if that's okay.
Thank you.
They have covered pretty much everything, but I wanted to say that we did have an audit at the beginning of this year by the state, and we had a complete clean inspection report. We also had an FDA inspection report 3 months ago, and we had one observation on a medical device. So I'm trying to explain the improvements that we have done since the previous inspection. We have changed our minds because we have plans of expansion into the West Coast, basically. So we are very interested in getting the permit if it's possible. And also, if I may, our products are dental. There's dental and oral, the way we see it. Dental is for the clinics and oral is for the consumer. Dental drugs are all, except for one or two that I know, which would be injectable anesthesia and a chlorhexidine rinse. All of them are unapproved drugs, and all manufacturers have the same identical registration. That includes Colgate, Oral-B, all the big players. So when we see the pharmacy and the drugs, we don't see them, even the dealers don't see it as a drug, they see it as a dental product, unfortunately. So when this happened, my fault, I should have checked, and I didn't check. And the dealer never mentioned anything until I guess they had an issue, and then they reported it to us that we needed to get a license. Knowing the state of Florida, I immediately said, let's apply for the license. When I decided to cancel, I didn't expect this issue to be this big. But it's 100% my fault.
Thank you. Appreciate that. Board members? We're open for discussion.
So you already mentioned so your products, like you have two lines, one for dental, right?
No, we ourselves make dental products that are used by the doctor or the hygienist in the clinic.
Okay.
But in the dental, we divide products that are oral as to products that could be like a mouthwash, a regular mouthwash, because you can sell it to the consumer. We don't sell it to consumers, we sell to dental clinics. As a matter of fact, this toothpaste that I know is never sold through a pharmacy. A doctor will not prescribe it. A doctor will buy it from a dealer, and he will sell it or dispense it to the patient if the patient needs it. So it's a very unique market.
Okay. And are you planning to expand to different area in manufacturing?
Well, we have been selling in several states, and we have plans to expand. Yes, our company has been expanding, and we would like to continue.
So we have over 33,000 drug products shipped into Arizona without a permit. So traditionally, we will allow the applicant to negotiate with the executive director. Is that something we are thinking about now?
I would be agreeable to that.
All right, I'll make that my motion to negotiate with the executive director for a consent agreement for disciplinary civil penalty. And then if signed and paid, approve the application.
Mr. Chair, we may have to take a step backward to rescind the denial first
Yeah.
and then move forward.
I guess let's modify that to rescind the denial and then offer, well, would we offer the consent agreement and then if signed and paid, rescind denial, issue permit?
Yes.
Okay, that would be my motion.
Second.
And if I made the motion reference disciplinary civil penalties.
Correct. Isn't that what it generally is? Is it it's a disciplinary civil penalty?
It could be either one. You kind of leave that up to me on which route we want to do.
Yeah, I'll leave it as is. Any further discussion?
Could you clarify? We're not changing the motion, so it's discipline.
Correct. All right, Dr. Gandhi, roll call, please.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Nay.
Mr. Al Nassif,
Aye.
and Mr. Anderson.
Aye.
Ayes have it, Mr. Chair.
Thank you. Thank you for being here.
Thank you.
Thank
For
you.
your time.
All right, looks like we're on 26G. This is a deviation request. Is Borrow Neuroplex Infusion Pharmacy in the room or on the line?
Yeah, I'm present.
Hi, could you please introduce yourself for the record, please?
Yeah, good morning, members of the board. My name is Paul Fry, and I'm the operations manager for St. Joseph's Inpatient Pharmacy, and I provide direct oversight of the Barrow Neuroplex Infusion Pharmacy.
Welcome, Mr. Fry. We have Mr. Patel here from our compliance officer team. Could you provide us a summary, please?
Sure. Compliance Officer Chirag Patel. Barrow Neuroplex Infusion Pharmacy submitted a request for a renewal of a previously approved deviation. The deviation was initially approved and issued during the June 2022 board meeting, and it was renewed at the June 2024 board meeting. This deviation allows for pharmacy staff to stock an automated dispensing cabinet, specifically an Omnicell, which is located in an attached infusion clinic medroom with non-controlled drugs. This Omnicell is owned by a practitioner, and the drugs are ordered and owned by the practitioner also. The deviation is sought to have the ability for pharmacy staff to stock the Omnicell. This in turn prevents delays due to machine stockouts and allows for pharmacy oversight of medication storage in the medroom. The compliance officer has noticed no compliance issues in the previous inspections.
Thank you, Mr. Patel. Mr. Fry, would you like to make a statement before we move to questions?
No, Dr. Patel summarized it pretty well. I think the biggest thing was just the Omnicell's inability to generate a board-approved label containing, full outpatient prescription data. So that was kind of the part that doesn't fit the statute.
All right. Thank you, Mr. Fry. Board members, any questions?
Given the fact that this has been in place and the compliance officers have no concerns, I'd make a motion to approve.
Second.
Any further discussion? All in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries. Thank you, Mr. Fry, for being here. Thank you, Mr. Patel.
Thank you.
Moving on to 26H. This is for Wedgwood Pharmacy LLC. Is there a representative from Wedgwood? Oh, here we have in person. Wonderful. If you could please activate the microphone and introduce yourself for the record, please.
Yes, my name is Paula Booker, and I'm pharmacist in charge of the Chandler operations at Wedgwood Pharmacy.
Hi, Ms. Booker. Welcome.
Just for everyone's knowledge, I am familiar with Paula. It won't affect my judgment, but wanted to make that clear.
Thank you, Ms. David.
I would also like to make that statement. I've worked with Paula and it will not affect my judgment.
I know Paula as well.
I've been around for a while.
I don't know her, sorry.
Okay. But we need to have a quorum, right? So.
All right. Mr. Jacobson, could you provide a summary, please?
Thank you, Mr. Chair. Max Jacobson, Compliance Officer, Board of Pharmacy. Wedgwood Pharmacy is a wholesaler. It's named Wedgwood Pharmacy, but it's permitted as a wholesaler. They are a wholesaler for the Board of Pharmacy. They are an importer registered for the DEA. So I just want to start with that to make that very clear. We call them Wedgwood Pharmacy, but they are a wholesaler. This special request is before you today for approval to import 2 drugs that are single source, manufactured in South Africa, not available anywhere in the US. The request is for Wedgwood Pharmacy to import these drugs, and specifically the board to grant approval for importation of these drugs. Prior approval was granted on page 5533 of your board book. I put that in there as an example of what we're trying to reproduce or trying to grant another approval today. On page 5536 in your board book, you'll see references from the DEA indicating that they accept this practice and approve of this importation. Originally, this request was just for thiofentanil, but recently the DEA labeling for etorphin has also come in. Both of these drugs are C2 opioids, something like 1,000 times more potent than traditional morphine. The reason for these drugs is because they're used in zoos and in wildlife veterinary practice for large animal immobilization, anesthesia, that sort of thing. And I'll stop there. I think that's appropriate.
Mr. Chair, this approval took a lot of effort with communication with the FDA, DEA, even our governor's office. So they're all in alignment with this approval, and we do have statutory framework that allows for this practice to take place because it is a sole source. The approval is not an ongoing forever approval, because at some point maybe there is an alternative, and then at that time this authority would cease. But just want you to know that there was a lot of effort and communication back and forth with all the required people.
So what's the requested extension time period through?
FDA approved 1 year. I don't believe we've requested a time period. Did Wedgwood request a time period?
No, I think so it looks like we yearly do this and request the extension of it. So
okay. Board members, any questions?
Sorry, Max, you're comfortable with the security pieces and everything. I know that when we initially discussed this, we were concerned just because of the potency of this drug and making sure that there was nothing that would get out on the street that could potentially harm citizens. You're comfortable with all of the security provisions that they put in place?
That's correct, Dr. Walmsley. A team of compliance officers visited the site and reviewed security, the facility, the process, and we were comfortable with all of it.
Okay.
We also confirmed with the DEA that they are also.
The DEA is also comfortable with it. Given those comments, I'd make a motion to approve.
And second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you for being here, Ms.
thank you. Thank you, board. And it's nice seeing everybody again.
All right, moving on to 26I. This is discussion, consideration, and possible action regarding the request made by Create Pharmacy Group LLC for reconsideration of the imposition of a disciplinary civil penalty in board case number 26-0230 relating to its renewal application.
I'm recused from this one.
Thank you, Dr. Davis. And for Create, we've got a representative. Could you please introduce yourself for the record?
Yes. Good morning, Mr. Chair. My name is Ty Doyle with Baker Hostetler on behalf of Create Pharmacy.
Thank you, Mr. Doyle. And we have Ms. Mitchell and Mr. Carlapudi, who would like to start with a summary, please.
I'll start.
All right, very good.
Okay, at its meeting of April 15th, 2026, the board considered the permit renewal application for Create Pharmacy Group LLC. After review and discussion, the board decided to approve the renewal application on the condition that the applicant pay a civil penalty to be negotiated by the executive director. On April 22nd, 2026, Cam Gandhi, executive director, reached out to the applicant to obtain the information necessary to start the negotiation process. After receiving the information from the applicant, Dr. Gandhi offered the applicant a disciplinary civil penalty of $115,960. On May 15th, 2026, legal counsel for the applicant submitted their response to the proposed civil penalty. The response is in the board's materials.
Thank you, Ms. Mitchell. Mr. Karlapudi.
Hi, this is Ram Kalapuri, Compliance Officer with Arizona State Board of Pharmacy. Looks like the mic is too close. Sorry. I'll recap the fines paid by Create to other states and some developments since our last board meeting. Create shipped total of 5,798 non-compliant prescriptions into Arizona. Create paid $200,000 fine in July 2025 to the Ohio Board of Pharmacy for the same activity for shipping 41 compounded prescriptions with 8 drugs that were not in any categories. Also paid $5,640 fine to Louisiana Board of Pharmacy on 11/19/2025 for shipping 365 compounded products with unapproved bulk drug substances that are not eligible for human compounding. And a recent development, Indiana denied Create's license, and also they referred the nurse practitioner who prescribed retatrutide to their respective nursing board. Even if Arizona State Board of Pharmacy rule allows pharmacist professional judgment, in my opinion, the professional judgment is misguided. It's not sound or good professional judgment. The reason for that is pharmacists selected new drugs with unknown, in some cases, known safety risks, also violated 503A federal statutes, introduced new drugs into the market circumventing the FDA new drug application process required for usually traditional manufacturers doing all the clinical trials, assessing safety, etc. Possible violations, in my opinion, are statutes 32-1901.01, definition of unethical conduct, unprofessional conduct. In the chapter, it says, unless the context otherwise requires for the purposes of disciplining a permittee, unethical conduct means the following, whether occurring in this state or elsewhere: violating a federal or state law or administrative rule relating to the manufacture, sale, distribution of drugs, devices, poisons, hazardous substances, or precursor chemicals, and also 32-1967, it's acts constituting misbranding of a drug or device. That's all I have to contribute. I am ready for your questions. Thank you.
Thank you, Mr. Karlapudi. Mr. Doyle, would you like to make a brief statement before we move into questions? And specifically, what is the special request?
Yes, thank you, Mr. Chair, and I will be brief because obviously we submitted a letter in some detail, and I don't want to reiterate and thereby waste this panel's time. I would refer the panel to start to the Supreme Court case of Arizona v. United States, in which the state attempted to enforce federal immigration law, arguing that there was essentially a gap filling. And the Supreme Court said unequivocally, states may not enter in any respect an area the federal government has reserved for itself. What we're hearing today is that the penalty is predicated on a violation of Section 503A of the FDCA, a federal statute. That is not a basis for a civil penalty here. To the extent that there would be a basis, arguably, in the Arizona Administrative Code R4-23-410. We obviously briefed that at length. We believe that there's been a misreading, but then ultimately the proposed civil penalty here, $20 per substance shipped, does not bear any comparison to recent history here, and does not have any statutory support. As best we can tell, this is $100,000 more than anything that has happened in the last 4 to 5 years with respect to a pharmacy, including the Havasu pharmacy, in which you had people practicing without licenses in Arizona. And ultimately, we want to find a reasonable solution here. I'm obviously not doing this pro bono, and so as we said during April, we'd like to get, a reasonable resolution here, but this seems to be predicated on a violation, one of federal statute, and then an amount that doesn't comport, with prior civil penalties.
Thank you, Mr. Doyle. Board members? I will make a statement. The board is not enforcing, we are enforcing federal law, but we're enforcing Arizona pharmacy law. I mean, under Arizona statute, unprofessional conduct includes violating any federal or state law related to drug manufacturing, distribution, or pharmacy practice. So when the board expects compliance with federal compounding standards, it's doing so with its own independent state licensing authority over pharmacies that operate and ship into this state, like yours. So in other words, adherence to federal compounding standards and requirements is part of lawful practice under Arizona law. So it's not overarching or overreaching our enforcement action. We talked ad nauseum about the three independent options, and we all agreed at the last meeting that the rule in question, R4 23-410, needs to be read as whole, and I think creates interpretation. Under your interpretation, a pharmacy could potentially use almost any substance, as long as the pharmacist personally considers the supplier acceptable. And that concern would effectively eliminate important safeguards. And we're here to protect Arizonans. And I think that the $115,960 is a smoking deal for Create to continue to distribute into the state of Arizona. And we just heard from Mr. Carlo Putti that you guys paid $200,000 to Ohio. So it's far less than what you paid to Ohio for far less product. And we've had this discussion at the last meeting, and I think that the $116,000 is quite fair and equitable for you to continue to have the authority to do business in the state of Arizona.
I move we deny the request.
Second.
Any further discussion? Dr. Gandhi, roll call, please.
Mr. Chairman, you are denying the special request. Implied in that motion is for TAM perhaps to reoffer the consent agreement for a disciplinary civil penalty.
Yes,
Is that correct?
that is correct.
You ready, Mr. Chair?
Yes, please.
Mr. Thorwald,
Aye.
Ms. Browning,
Aye.
Ms. Davis, sorry, recused, Ms. Walmsley,
Aye.
Ms. Spark,
Aye.
Mr. Hogan,
Aye.
Mr. Al-Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Mr. Chair.
Thank you, Dr. Gandhi. Thank you, Mr. Doyle, for being here.
Thank you.
May I ask a question, Mr. Chair? Is it
Yes.
something you'd like us to refer to the Florida board?
Absolutely. I mean, I hear through, NABP and other options, other pathways that Florida doesn't allow these substances either. So it begs my question is, how is this pharmacy in Miami or South Florida, wherever, able to prepare these compounds using substances that aren't approved by the Florida board? So at least that's my interpretation of what's going on in Florida. Is that accurate?
I think once we forward it to Florida, we'll let them make that interpretation, but
Okay.
if you're okay with that, we'll send it off.
Yes, I think that would be prudent.
Mr. President, could we have a short break?
Do you want to just go to lunch now? Yeah, let's go to lunch. We'll be back in an hour. Let's take a half hour. We'll be back at 12:10. Is that sufficient? My apologies. Let's do the full hour lunch break.
I'm so confused.
All right, welcome back. We are back from lunch and we will go ahead and proceed with the agenda. Item number 26J in the board book. This is discussion, consideration, and possible action regarding the request made by Kumal Walij, pharmacist intern, to take the Naplex for the 5th time. Is Mr. Walij with us?
Yes, I am here.
Hi, Mr. Can you please introduce yourself for the record?
My name is Kamal Walji, a pharmacy grad intern. I'm applying for the 5th attempt for the exam.
Thank you, Mr. Walji. Is there any chance you have a camera you can activate for us?
I could, but I do have a fever at the moment, so you will have to excuse my sweats.
No worries. We're good.
Okay.
All right, board members, any questions for Mr. Waliji?
In case we approve your request, this is your last chance, correct? Are you prepared?
Yes, I am. I am prepared, and I am aware that this is my last chance. Yes.
Okay.
Any further discussion? Anybody willing to make a motion?
I move to approve the request.
Second.
All in favor, please say aye.
Aye.
Any opposed? Motion carries. Good luck, Mr. Waliji.
Thank you. Have a wonderful day.
All right, moving on to 26K. This is discussion, consideration, and possible action regarding the request made by Donia Gaharian, pharmacist intern, to take the Naplex for the 5th time. Is Ms. Gaharian on the line?
Yes. Good afternoon, everyone's in the meeting. This is Donia Goharia.
Hi, Ms. Gaharian. Why are you here today?
Thank you for having me there, and I'm there to request for the 5th time retake of my Naplex.
All right, board members, any questions for Ms. Gaharian?
It's just like the same question I asked, this is your last chance in our state to take a Naplex. Are you prepared for the 5th
Yes, yes. Actually, I changed my strategy, my plan, and get very professional support. And for sure, yeah.
All right, board members, anybody willing to make a motion?
Make a motion to approve to take the 5th test.
Second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you for being here, Ms. Gaharian. Good luck on your 5th and last attempt.
Thank you so much.
All right, moving on to 26L. This is discussion, consideration, and possible action regarding Rami Chopa's request to waive the Foreign Pharmacy Graduate Examination Committee certification requirement for pharmacist licensure. Is Dr. Chopa here? Do we want to proceed?
I think so. I mean, given the nature of the request, it's not something that we're able to accommodate anyways, regardless of the request. So I would make a motion to deny the request.
All right.
Since we don't have jurisdiction to do so.
Thank you, Ms. Walmsley.
I second.
Any further discussion? All in favor, please say, do we have to deny, or is this roll call?
It is not.
Okay. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Moving on to 26M. This is discussion, consideration, and possible action regarding the request made by Jasmine Marion Negro for permission to proceed with an application to reinstate her revoked pharmacy technician training license before the 2-year period has elapsed. Is Ms. Negro on the line?
Nobody online, Mr. Chair.
All right. I think we have appetite to proceed without the subject.
I believe we can.
Okay.
Yeah.
Do we want to hear a summary from Ms. Perez, or do we just want to move forward? All right, Ms. Perez, could you provide a brief summary for the board?
Certainly. Good afternoon, board members. Bridget Perez, licensing administrator for the Arizona State Board of Pharmacy. Jasmine Marian Negro was issued a pharmacy technician trainee license on November 8th, 2022, with an expiration date of November 30th, 2025. On November 8th, 2024, the Arizona Board of Pharmacy issued a decision and order to revoke her license. Ms. Negro is requesting the board's permission to reinstate her pharmacy technician trainee license before the 2-year revocation period has elapsed for the remaining period left on her license. The remaining time left on her license before it was revoked was 11 months and 14 days. In May of 2024, board staff sent a complaint notice and subpoena to Ms. Negro's mailing address of record, notifying her that the board received a DPS notification regarding an arrest and/or charge on or about January of 2024. She was notified that the board opened a complaint and requested that she respond and provide a written explanation of all criminal charges, as well as copies of police and court records. The mailings were returned by the Postal Service with a note indicating the forwarding time had expired. The emailed notice did not bounce back. She responded to the email notice but failed to provide any of the documentation required by the subpoena. Pursuant to statute, she failed to notify the board of the change in her mailing address. It is also noted that she failed to notify the board of multiple prior charges in 2022. The conduct and circumstances described constituted multiple notification requirement violations and unprofessional conduct. Therefore, the board ordered Ms. Negro's pharmacy technician trainee license revoked. She was notified of her right to request a rehearing or review of the decision and order by filing a motion with the board's executive director within 30 days after service of the decision and order. No request was made. On December 17th, 2024, her license was revoked. Ms. Negro is appearing before the board to request to reinstate her pharmacy technician trainee license before the 2-year revocation period has elapsed. She has not submitted an application for reinstatement, as a trainee reinstatement application does not exist. Approval from the board will result in the request for reinstatement being added to a future board meeting agenda for consideration. Thank you.
Thank you, Ms. Perez. Board members, any questions, discussion?
At this time, I don't think we should accept her request. It's been not even a year. She has not shown up, and there is not many communication with her. So my motion would be to decline her request.
Thank you, Mr. Nassif. Do we have a second?
Second.
Any further discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. Moving on to our board member training provided by our Assistant Attorney Generals.
Hello. Allison Franklin, Assistant Attorney General. I know we're in the final stretch today, so I'll try to be efficient. Today, I'm going to talk to you about the adjudication of complaints. Next slide, please. The board resolves complaints at public meetings like the one we are currently at. It's important to know the stage of the proceeding because the board's options may vary depending on what stage of the proceeding we're at. So for example, your options at first case discussion will be different from those at a formal hearing. And just to list out a couple examples, at your first case discussion, the board may dismiss, issue a non-disciplinary resolution, offer a consent agreement for disciplinary action, request further investigation, or refer the matter to a conference. At a conference, you also have your non-disciplinary resolutions. You can offer a consent agreement for disciplinary action. You may refer the matter to a formal hearing. And then formal hearings are typically reserved for suspension or revocation, and you can issue discipline at that point. Next slide, please. Licensees are entitled to have the board make decisions based solely on the facts presented in the case at hand. So those facts will be from the information and documents provided by the complainant, the licensee, or the applicant, the compliance officer, the staff investigator, and then potentially a professional consultant if there is one involved. If you need additional information, you may ask staff for clarification or direct staff to obtain that information. But under no circumstances should you do your own investigation or your own research, as that may disqualify you from participation. And sometimes a licensee might be before you and you recognize them from a prior matter. It's important not to ask questions about previous board actions unless the board has determined that a violation has occurred in the case at hand. And that is because a licensee's disciplinary action or history, apologies, is relevant only to the penalty and not to whether the allegations in the present case are true. So a licensee may have, committed a violation 2, 3, 10 times before. That really only comes into play in terms of penalty. You may want to issue a harsher resolution because of that repeated pattern. But because they had those prior violations, it doesn't necessarily mean that they committed the violation in the case before you. So stick to the facts in the case at hand. Next slide, please. When resolving complaints, you may wish to ask yourself these questions. What are the allegations? What information do I need to determine whether the allegations are true? Do I have that information, or what else would I need to know? What information is credible and persuasive? And if the allegations are true, what penalty is appropriate? And this is also where your complaint grid comes in. That's in the beginning of your board book. Try to be consistent in decision making. Cases come in a case by case basis. The facts are different in each case. But if you are deviating from a normal resolution, try to make sure that you are clearly articulating what facts are making it so that you're offering a different resolution than what you normally would. Otherwise, we want to make sure that we are consistent to avoid challenges that the decision making was an abuse of discretion. Next slide, please. Motions. In order to take action as a board, the board needs a motion, a second, and then an affirmative vote of the majority of the quorum. To complete a motion, the motion needs to be made. It needs to be seconded. It needs to be repeated, discussed, voted on, and then the result of the vote should be announced. To kickstart this process, the chair will ask, do I have a motion or is there a motion? Next slide, please. In order to make a motion, the magic words are I move that or I make a motion that. So saying something like, I think we should do XYZ, or I want to do XYZ, or even, this is a tricky one, but even if saying I motion to XYZ, these types of statements are not motions technically. You really need to be saying I move that or I make a motion that. And then if you hear as a board member, another board member say a statement like, I suggest that we blank, don't second those statements. And remember that a member of staff is writing down each motion as it's made. So you want to make sure that you're clearly articulating what your motion entails. If it's a consent agreement, what are the terms of that consent agreement? And make sure that the motion is adequate and complete. Next slide, please. Then another board member will say second or I second the motion. If there isn't a second, then the motion dies. Next slide, please. And then the procedure for this board is to open with discussion, and then a motion is made or the chair asks for a motion. There's a second, and then the chair will call for additional discussion. So during discussion, we want to stay focused on the allegations at hand and avoid drifting to other topics. Next slide, please. And finally, the chair will call for the vote. Usually a voice vote is sufficient, But when we are imposing discipline as a board, we want to do a roll call of each member. Also remember, no anonymous voting, no secret ballots, no asking the person next to you to vote for you while you run to the restroom. Don't do that. If it's a voice vote, the chair will ask all those in favor, all those opposed, and then ask if any board member is abstaining from the vote, and then the chair will announce the result of the vote. A tie vote, of course, means that the motion fails and the chair will ask for a new motion. Next slide, please. That's all from me. Very quick today. Thanks, guys.
Thank you, Ms. Franklin. All right, we'll move on to tab 28, discussion of items to be placed on future meeting agendas.
Mr. Chair, I proactively added one regarding requesting a permission to deviate from having a little lapse in. Let me get that for you. One moment. The FPGEC certificate, as it's not in our statutory authority to grant that deviation anyways. We've had a couple of matters come before you, so I'm going to put it on the agenda to discuss how we as board staff can just take care of that behind the scenes and not appear before you.
That's wonderful. Thank you. Mr. Nassif, you generally have something.
Yeah, but I've been shut down multiple times. So I say, you know what? It's better not to share my ideas.
Okay.
I'm just joking.
Tongue
Dr.
in
Gandhi
cheek.
doesn't like my proposal.
I have a tongue-in-cheek proposal, but it's serious. How about having a humanoid come and testify about the futures of pharmacy and robotics?
You need to come to the NAVP meeting because there was a robot
I was-
there. It didn't work as proposed, but they had a robot.
So Dr. Gandhi, maybe we already have it, but I'm not aware of it. It's about when we approve deviation request. Some of them has 2 years end date, some of them unlimited maybe, because you cannot give 2 years for size, right? So that you approve it or not. We need maybe to discuss it for more clarity, or maybe deviation has to be like we have to specify like which one is limited to a certain time, which one is endless. Otherwise, we're gonna come like have those questions. Yeah.
I think we just need to revisit the rules because we never don't approve them. So why do we have the rule? I know I'm a broken record. I've said that I don't know how many times. Okay.
So I know we had discussions a couple of meetings ago about the term apothecary. Do we need to talk about that again? Or I know the AG's office is working on potentially something.
It is on our homework assignment to do some homework regarding it, and then we'll bring it back to you at a future meeting.
All right, very good.
Medical appliance approvals and how we still can get the word out about that and talk to companies that are still here in the state that we know of that to get some of those issues resolved.
Board members, anything else? All right, we'll go to call to the public.
Roger Morris, Quarles and Brady. I have a couple of items. First, I wanted to thank a couple of the former board members, Kristen Cinema and Cedar Lahan, who were kind enough to attend the Midwestern Pharmacy Law class, where we take a deep dive and video review of some of the board's actions from last year to be able to do it. Unfortunately, the class overlapped with the NABP meeting, so some of you folks weren't able to do it. They did a terrific job, and the students had a great deal of information and issues with it, so thank them. And hopefully we won't have that conflict next year, and we'll see if we can get some other folks that are able to do that. Mr. Thorold mentioned humanoid, but I wanted to raise an issue that's a real issue that's pending right now. I don't know how many of you have seen, but Utah has a law in a sandbox law that allows the sandbox, it's a Utah special board dealing with AI, to approve things that supersede other Utah laws, medical board, pharmacy board, and the like. And Utah has now approved the AI issuing of prescriptions, meaning that there is not a human involved. It is AI issued prescriptions that will be valid prescriptions in the state of Utah for Utah residents. It will go live as of July 1, and I'm already getting questions from Arizona pharmacies. Am I allowed to fill these prescriptions? I have raised the question with board staff, and it's my understanding that you have tendered a question to the AG's office. But Arizona has always recognized the validity of prescriptions from any other state. And frankly, Arizona recognizes the validity of prescriptions from any other country in the world with it. But this is a new frontier, and I think we need to be talking about this. And I know you guys already talked about future agenda, but this is going to be another one that's there. It's just sort of an interesting process as to how we do this. So if we recognize, I'm making this up and I'm not trying to cast aspersions, but a witch doctor's prescription from Ethiopia, I'm not sure why we would or would not recognize an AI prescription approved by the state of Utah, but we need to have discussion about it. And there will be real issues before your next board meeting as to it. It is not controlled substances, but this is not a future issue. It is a now issue. So I wanted to make sure you guys were aware of that. This comes up regularly, and I think the board could do well to clarify this. I know we ask questions about, have you ever been disciplined or fined or other things for folks, and we get into questions about whether people have appropriately disclosed. One of the issues that comes up is FDA Form 483s and warning letters. Those are technically under the law, not discipline from the FDA, but we seem to be reporting that people failed to report that they had an FDA 483. I think we could clarify a lot of this by just putting in the question, have you ever received an FDA warning or form, and not sit there and accuse people of saying they did or didn't disclose something, because technically they're not disciplined, but I think we want to know about it. So I raise it for that one. Next one, the UMPJE, there was a really short report on it. I forwarded this document earlier today to Dr. Gandhi, but this morning, Maryland sent out an update to its folks saying that as of June 1, Maryland folks who want to be licensed in Maryland have the choice of taking the UMPJE or a state MPJE, the old-fashioned one that is there. So they're giving them a choice. But if they take the UMPJE, they will also be required to take a Maryland-specific module similar in design to a CE program consisting of recorded materials and a competency assessment to be able to do it. So what they're saying is, at least in Maryland, they think people need to at least have some working knowledge of Maryland law. Just taking the UMPJE has no assurance that anyone has any working knowledge of Arizona law. So I thought the Maryland one is an interesting compromise that's out there, and it may be something that you want to consider going forward. But I said it just came out this morning, and I did forward it to Dr. Gandhi so he could look at it. Let's look at a couple of other ones. Oh, I think there was a request to have somebody present a life lesson about choices at the Midwestern and U of A pharmacy law class. As long as I teach the Midwestern class, I'm happy to have those people speak on it and anything else. Now, that being said, there is a change in curriculum at Midwestern, and they're moving it from a beginning of first-year class to a end of second-year class. So there will actually be a year where there is not a pharmacy law class taught, which is coming up right now to be able to do that. So when somebody says we'll make an effort to do it, sometimes the universities change curriculum and formats. And so I just wanted to point that one out. And then last comment I had before my fun one with it is we were talking about preceptors and what preceptors' roles are. I have always understood a preceptor is responsible for the training of the intern, but a preceptor is not required to be there minute for minute that the intern is there to be able to do it. The preceptor is responsible for their overall training at the pharmacy. That being said, an intern has to have a pharmacist present every minute that the intern is working. Doesn't have to be the preceptor, just has to be a pharmacist that's there. And I don't think that position has changed for the Arizona board on that one. So it's an interesting one. If you say someone can't be a preceptor, they may still be in the position where they're supervising an intern while they're there to be able to. And my last sort of fun one, I don't know if we ever going to go back to it, but this board used to have summer rules, and summer rules where we wore polo shirts for the summer meetings rather than jackets and ties and dress to be able to do that. Thanks.
Thank you, Roger.
I love that one. So August meeting, no ties, gentlemen.
Tariq is not wearing a tie for the record, nor Chris.
They started a good
I
trend.
just followed Chris. I saw him yesterday. I decided not to wear it today.
It's not on the agenda to discuss today. We'll put it on a future agenda item.
I think
He got a phone call.
Sure.
Good afternoon, everyone. I'm Jamie Von Glon. I'm the immediate past president of AZPA. And I wanted to say thank you to Cam, our executive director, with an award. I'm sorry. I didn't know it was taped. We wanted to give you an award, and I know you couldn't be there for the annual convention, but it's a Pharmacy Appreciation Award, and we want to appreciate everything that you do. All the laws that you've put through, everything you help us with, we really do appreciate it. Yeah, thank you.
You made it.
Thank you.
I will use AI to add my picture next to them.
All right. All right. We are now adjourned. Thank you. We'll see everybody in August.